pardon to make a mention. Since your lordship is specifically taking up hearing matters tomorrow, your lordship had expressed that tomorrow we can mention we are ready with the hearing. The appellant is 86 years old and he has gotten bedridden. It's a small matter. Your lordship may take up for hearing tomorrow. CRLA 283 of 2005.
Tomorrow we'll see tomorrow.
Your lordship may at least bring it in the list tomorrow. I have given the
It is already listed for tomorrow.
Your lordship had earlier, it was there in the weekly list. Your lordship had said that.
We'll see tomorrow how it moves. We'll see.
Much obliged.
Yes.
Yesterday my item has been came, but it's not been sorted for any reason. But for the urgent delivery of the education of the opposite party number 3, this can it come tomorrow or Monday?
Take it, we'll see. Adjust to it. Next week.
CMP, I've given the memo, it's a after notice matter will be watching. Could take it next week.
Yes. Let us see page wise call. Yes.
Item 1 to 3.
That's the first item. As the Oxford is constrained to motion if the council has not been recovered from the chemotherapy with 10 days time, otherwise we'll argue the matter.
Counsel for the petitioner, Mr. Marana, and counsel appearing for the Mr. Mohanty, SJ Mohanty, yeah?
No, it's a fee partition. That's your lordship record. Fee partition.
Fee partition. Submits that he is suffering from cancer and undergoing treatment, and he seeks an adjournment for
Item 3, your lordship.
3.
Item 3, your lordship.
Yes, 3.
Item number 2, my lord.
2, yes.
Okay, and we will take it.
On the request of you are for Mr. Das.
Petitioner.
Petitioner.
My lord.
Oh, petitioner.
Item 3, your lordship.
Yes,
Item 3.
Item 3. This is the third time the petitioners are taking adjournment.
Mr. Pradhan, your lordship.
Opposition, let it be there. Yes.
Your lordship, item 3, your lordship. Mr. Pradhan has some difficulty, your lordship.
3, he is opposing. We'll see.
Next to candidate, your
He
lordship.
is opposing, what to do? I'll have to see. Why opposition? You are opposing, no? We'll see. Next.
Item 4 to 13.
Item number 13. It will come next week on behalf of the petitioner.
Petitioner request, 13. Yes.
My lord, item 11. On behalf of his party, my lord, kindly taken on next week.
Okay. On petitioner councils. Yes.
Item 14 to 28.
Item 16, madam.
Council petitioner? For petitioner, Yes.
May
16.
Item
Yes.
19, my lord. I am praying for adjournment. I am appealing for the petitioner, my lord.
Petitioner. Okay.
Obliged.
My lord, item 26.
Yes.
1 week after.
Petitioners council.
Item 29 to 39. Item 40 to 45.
My lord, item 40, I am praying for an adjournment on behalf of Ms. Mishra.
40. Okay. 40.
Item 46 to 49. Item 50 to 59. Item 60 to 65.
My lord, item 62.
62.
For the respondents are seeking for an adjournment.
Huh?
For an adjournment.
This is 2016 matter. Okay. Okay. Review petition. Yes. Okay. Okay. Yes.
66 to 74.
74, my lord. 74. They are not soft copy, my lord. For which you could not file the written notes of argument. The petition are not a soft copy, my lord. For 1 week after.
On behalf of counsel for the
74.
opposite party.
Item 71, my lord. The matter is compromised and they will.
1 week after, my lord. 1 week after.
You also may fix the timing at 2 p.m.
Come at 2. Okay.
Item 75. Last date as per Lordship's order, CD was called for, but it has not been produced yet. Kindly one more intimation and a short date may can.
Counsel for the petitioner. Adjourn. Yes.
Item 75 to 82.
82, my lord. Kindly be taken 2 weeks after, my lord.
Counsel for the petitioner. Yes.
Item 83 to 90.
6 lords. You can take up 1 week after, lords.
86, huh?
My lord, item 89.
Sufficient.
My lord, item 89, my lord, a compromise matter, my lord. Today parties have not come, my lord. Next date may be given, my lord. Next week, any date. 89.
89 outward. Okay. Good. Okay.
Oblige, your lords.
87. My lords, there are two matters for quashing, my lords. In the first, my lords had issued notice, but since no one has entered appearance, and second also the notice may be issued and a short date may be given. Parties have already compromised, sir. The first one was domestic violence, second one is a GR case under 498A.
No notice?
Sufficient.
Notice sufficient. Let us see who.
My lord, the first one. Oh, I'll wait.
Let us see who calls.
Oblige.
Item 3. Yes.
Lordship, item 3, your lordship, on
Yes.
Mr. Problem, your lordship. Can be taken up next week, any day, your lordship.
What is the problem?
Problem, your lordship, Mr. Pradhan, some relation is admitted in the hospital, your lordship. Therefore, I pray next week, any day, your lordship.
Vishnu Pradhan.
Yes, lord.
Vishnu Pradhan.
Yes, lordship.
My lord, it is the third time that, my lord, I have no objection in time, but there I have filed the IA for
But counsel is not well.
but this sorted may be fixed because the third time your lordship is
The
recently.
ground of health, at least of
Mine,
counsel,
mine.
we should not. Okay. Which item?
So,
Sub item, your lordship. One sub item, your lordship.
my lord.
On behalf of Mr.
Final disposal matter.
Yes, action is made by 11 council that Mr. Pradhan is not well. However, the adjournment is opposed by Mr. Hon'Ble. This is the matter.
3 to 4.
All the procedural
It is taken up 3 p.m. The final disposal
No,
matter.
day time, giving time is very,
My,
very.
it is a case where the moderate trial has been stayed, my lord. So it is the third time the date is being rescheduled. Right? The final hearing
I am
is
giving a short date
sorted, my lord.
because it's health problem.
My
Yes. In all the cases, your lordship, interim running continue. Problem.
Item 4.
Name please, your lordship. Well, lordship, as dated 16/11/2023 before your lordship, my lords. It's a case, my lord, where lordship kindly turn to page 12, annexure 1. This, my
Yes.
lord, say FIR was lodged by vigilance, my lord. Relevant page is page 14, lordship, kindly. Turn to
1-4.
1-4, lordship.
Yes.
A FIR was.
Who are you? You are
Yes.
Mr.
A written report was given.
Antunu.
Lordship.
Yes.
I am a dealing assistant, my lord. What is the allegation, my lord? Para 1, this inquiry, my lord, basing on which this FIR has been lodged, inquiry reveals that in each education session there is provision of sanction disbursement stipend to the SC/ST borders and day scholar students. And last part here, the 4 lines from the below the first paragraph, as per guidelines in the second paragraph, I am placing, lordship, kindly see, as per guidelines of the House and Tribal Welfare Department, the stipend of SC/ST border students shall be disbursed through joint bank account opened in the name of students and headmaster of the school, and the stipend of SC/ST day scholars shall be disbursed through joint bank account opened in the joint name of the students, their guardians in the nearby commercial bank, my lords. There is also inquiry, my lord. Your lords, you kindly turn to page 15. I am not placing in detail. Page 15, my lords.
50?
Second, page 15, lords.
1-5.
Yes.
Yes.
What is the role played by the present petitioner, my lords? This second paragraph, my lord, this say, my lord, towards last 2 lines, that this the above stipend amount has been sanctioned by the BDO, my lords, and recommendation of welfare extension officer, my lords, Sri Khuntia, and the amounts were released by the headmaster. Headmaster is also not before your lordship.
You have maintained the
only yes, only what I yes, and the last that paragraph. What is there, my lords, against me?
Junior clerk. You are the junior clerk.
In the names of at SDFC Bank, Devagad, as well as stipend disbursement registered maintained in the school by Santanu Kumar Nath, junior clerk. So, my lord, my humble contention before lordship is that amount has been recommended by the welfare extension officer, sanctioned by the BDO, disbursed by the headmaster.
Deposited in the headmaster joint account.
And also, lordship, kindly keep in mind that it is all bearer checks, my lord. There is no cash transaction, no online, nothing, my lords. And also, this being the appropriate authority, headmaster has the disbursed to the students, my lords. My role is being, I am the
disbursed or not, that is a big question.
Yes, my lord, that is
a big
the scheme, my lords. That is the scheme, my lord.
Big scam.
Yes,
in the name of a SC/ST student, there may not be any student at all.
My lords, I am
but money comes.
Yes, I am very much conscious about this, my lord. So,
yes. What do you say?
This is a big scam, everybody knows it. Including Mr. Manti, he also knows it. But what is his role? Being a junior clerk.
He was preparing the register. He has shown the register showing the name of the student twice. And all have connected with each other. False register has been maintained and false voucher has been prepared. Everything has been done and exam has been done and trial number is going.
My lord, 2009 FIR, 79 witnesses, charge sheeted witnesses, 7 witnesses examined. In the meantime, 15 years have passed, my lords. And next date is 24. Your lordship, lordship, kindly call for a report by what is the, my lords, because I say.
Okay, 2009, let us see.
7 witnesses examined.
What are you seeking? Causing of what?
Yes, lords. Yes.
Charge, when the trial is proceeding.
Well, I am very much conscious about my prayer. Only what I pray, your lordship. Your lordship, kindly call for a
expedited trial.
Yes,
I'll call for a report.
Yes, I am conscious about my prayer.
Yes, Mr. Mantin and counsel for the petitioner submits that the petitioner is one of the accused in Sambalpur Vigilance PS case number 5 of 2009, which was registered on 28/1/2009. The only allegation against the petitioner is that he being the he was working as a junior clerk and maintained the register of the SC/ST border students who has got stipend through their bank account, a joint bank account with the principal of the school. He submits that despite there being no case against him, he has been suffering the ordeal of the trial since 2009. Let a report be called from Special Judge Vigilance Sambalpur regarding the status of the trial. Lease the matter on. Yes.
If your lordship kindly reflect 7 as per my instructions, 7
I will not say anything. Let us see.
Grateful.
Item 5.
Item 5 was issued in a execution proceeding for realization of the maintenance amount of 4,71,000. I only pray some more time.
The principal order is there. Maintenance order is there. You do not challenge. So you have to pay it.
Now, what has happened, Lord? That order of granting maintenance has already been set aside. That is my today appeal was kept for judgment, and judgment has been pronounced, and the order has gone. So I just want to verify whether
I will simply adjourn it. Verify and tell me what is this.
It's unnecessarily taking time.
My lord, I am now going to file application for realization of that amount which he has taken.
No, what he says is the maintenance order which was in your favor, which you are seeking to execute, that order is set aside.
Set aside is Sakal judgment pronounced.
That's what he says. I'll put it in next week. Tuesday, Wednesday, rakho. Tuesday, Wednesday, rakho. You tell me if it is set aside, what will happen? Whether you can still continue with the execution proceeding. If it is set aside. Payment in pursuance to a maintenance order which has been set aside now. That's what he says. Let us see. Tuesday I'll keep it. Come with that order. Let us see. Photocopy of that order. Certificate copy it's not required. Okay. Tuesday, Wednesday. Yes. Yes.
Item 6.
Yes.
UPID. UPID Vivekananda Bhujan.
Password. Yes.
Item 7.
Lord, so last order date 11-3, my lord. The last line, my lord, the order date 11-3. Lords, we record that parties have conjointly submitted, they have entered into settlement. In fact, they have entered some settlement. Now, both the parties have requested them, I direct them to come appear before my lord, because the offense is so serious. Both the appears, and since you have to.
Now, what are the offenses? If they might have compromised, but if the offenses are serious,
but
whether what the charge sheet is filed?
Charge sheet filed, my lord.
Let us see the charge sheet. What are the allegations? 366, 376.
Yes.
2N.
But regarding the
What
lordship,
is the settlement? What is the settlement?
regarding what they want, lordship, I have
Are
stated
they
my
married?
The petitioner is a married person.
Okay.
and both the lordship para can see my para 3, my lord.
Para 3
Of my settlement.
Then affidavit. Para 3.
Actually, my lord. ଭାରି 100-200 ମିଟର ଡିଷ୍ଟାନ୍ସ ହଉଛି 2 ଜଣ ଘର ଭିତରେ।
What is the stage?
My lord,
What is the stage of the case?
Trial has not been commenced.
କିଛି ହେଇନି।
କିଛି ହେଇନି। Trial commenced.
କିଛି ହେଇନି ମାନେ charge sheet filed. Thereafter what?
only till that's it. That's why I prepared.
Yes, yes.
Only charge has been framed.
Charge
No, no.
framed.
No, charge has not.
Charge is not.
Charge है।
That's why I brought 2 to 3 judgments supporting my lord and contention. You lordship keep it and can check up both the when they are intent to maintain a
See,
peaceful life.
para 3 you are reading, you simply say that you such a serious allegation you made.
Yeah.
And thereafter you say that we sat together and decided.
No, but because
And
the
you
allegation
initiate the case, you decide everything, then why
No, no,
should
no,
the
my
court
lord.
will be there?
No, I'm sorry to my lord. I am not saying.
That's what you have said.
Only my lord.
Para 3. I filed a case making serious allegations.
My lord, allegation.
And thereafter I sat with the accused and settled the dispute.
My lord, that's why I brought.
You are the creator, you are the decider and everything. Then
Sorry,
why the court of laws are there?
Leaving my lord's discussion, lordship can since both the parties are here.
Maybe, but what are the allegations? Just see the allegations.
Allegations, I know that that is my program. That's why I bring it to my lord's.
Then while making such allegation, one should be very careful about it.
The lordship, I bring that.
You make the allegation so serious allegation and set with the accused.
No, my lord, sad because
Cozily and in their house and decide the case.
My lord, both are related, but both only 100.
Close the courts then.
You're sorry, my lord. I can get leaving my lord discussion. Lordship, that judgment, lordship can fast judgment.
The problem is the type of allegation. Otherwise, see, the
lordship fast judgment. Lordship, that fast judgment can see, my lord. The para.
And the parties are there.
Yes, well, that's standing here.
What do you say?
Yes, ma'am.
They see.
Now, now courts are using as the instrument to regularize all this.
That's the whole difficulty. That's the whole difficulty. That's where the problem is.
And the petitioner is a married person also.
If this is more dangerous than the POXO case, you know. POXO case is a minor. They don't understand what happens. They indulge in some wrongdoing, whatever. Youngsters, adolescent people do it. But here the matured people, they do it and file serious case against the persons, and thereafter they sit together and settle.
Lordship, the fast judgment, I have bring my lordship para 19.
19?
The fast judgment at phase para 19, my lord.
19, 19.
19.
Yes. Yes, read it.
The guidelines, my lord, the Appeals Court says.
It is 307 case.
My lord. But that the guidelines is 19.1, 2, 3, 4.
That's right. This is a case for 307.
My lord. In the last judgment, also the allegation 376, 2N, my lord.
Which one? The first one? Second one, Kuldeep Singh.
Kuldeep Singh, my lord.
Yes. Read it. Which paragraph?
And that is, they both have married to.
Do you have 164 statement?
No.
164 has not been made.
No, I have not obtained.
Let us see the 164. Yes. Do you have that copy?
The last no, I have not that copy.
Get 164. Let us see whether 164, whether she is diluted or.
No, my lord.
161 is there.
The last judgment, lordship, you can see para 26.
Para 26?
Of last judgment.
The recent judgment.
Recent judgment, that's 24.
Yes.
These allegations is, my lord, 376 to N and everything there.
Yes.
In the present nature of relations between the appellant and the complainant can be characterized by the following two. The appellant and the complainant were acquainted. The user since 2008, the complainant herself admits that appellant has been in physical relations in the so-and-so without protest in spite of alleging so-and-so. Lots of that.
But what are the allegations in your case? Let us see. Let us come to the charge sheet. 161 statement is akin to the facts of this case, then you have a case. Let us see. Yes.
Is it matter?
Page 55.
No, last occasion, Lordship has seen the medical report, page 46.
Page 58 is the 161 statement.
Get 164 statement.
Yes.
I'll put it next week.
Yes.
You have something, akin to the facts of the last case.
My lord.
That at least you had relationship, not
My
that you had, but let us see this 160. I'll do it. Okay.
Both the parties are here, my lord. That's
Let them come once again. What? How does it mean? He makes such a serious allegation against him. Now he settled. They can come.
No, my lord friend is saying that he's appearing for the guard. He's saying that 164 record has not recorded.
Has not been recorded.
164?
Has
Not recorded.
Not.
The 161 show me.
161 is there at page 55.
Where is that? Page?
55.
Page?
55.
Shall I record that 164 is not recorded? Statement of 164 not recorded. Shall I make that?
He has submitted.
Huh?
He has stated that.
But
shall I record that 164 statement has not been recorded?
Let her say, my lord, that.
She will not know what is 164, 161. You must be responsible saying. For that, then I'll proceed. Let him. Let
it to Arjun, I will.
You get the 164. I'll put it next week. Yeah, next week.
They may not appear when they get record that.
They have to come. No. There is no leniency to these kind of people. Either for the victim, so-called victim,
right? I write
when I made such a serious allegation against him.
My lord, I agree that.
They should come. Why leniency?
No, my lord, because of.
Why leniency to them? Yes. Next.
My lord, that protection will be extended.
Let them come. Yes.
8. No course.
Next week. No, next week. Next week. Next week. Next week means I'll tell you. Next week means 7, 8, 11. Come on, 11th.
Item 8.
You have to make a specific statement whether 164 statement is recorded or not. He says no.
Yes.
Then you make that statement. I'll rely upon 161.
If recorded, I will get it, or otherwise I will specify.
Yes.
Item 8.
Yes.
So this is a check bounce case. I am challenging the cognizance on the ground that the check was issued with the condition that the check will be deposited under 2 eventualities. There is no agreement under Annex 3. Once if the property is sold or the films of the Rajara's movies are sold, then the check can be deposited. None of the eventuality was there. He filed a case that as if the check, there was a promise that the check will be honored within a period of 1 year. That is the complaint petition says that he has said, I am reading out the complaint petition where he has alleged that the party has agreed the check to honor the check within a period of, your lordship, page 17, my lord.
In this case, I am appearing for the opposite party number 2 on behalf of Mr. Sumit Mahanti, my lord, seeking on one adjournment, my lord. Tomorrow,
I have given the copies to them last time. This is my case, you just wait.
But last time he said that I'll file the reply. Sumit Kumar Mahanti and counsel appearing for petitioner.
Day before yesterday.
Yes.
Your lordship may kindly come to paragraph page 17, my lord.
17.
Paragraph.
1 minute, I'll accommodate. Wait, you want to say something.
Page 17, paragraph D.
Paragraph?
D,
yes.
My lord. 7th line from bottom, my lord.
Yes.
The accused had also given PTC check of such and such 12 lakhs. This is the present on the day 20th day of May 22 to the complainant that with a promise to honor the check and the amount payable within 1 year from the date of the given PTC. So accordingly, he has deposited. That is his ground matter. Now, lordship may see the agreement under Annex 3, page
Where is your reply to 138 notice?
I have not given any reply.
Then you have to face it.
You
This
know,
is your probable defense.
but Your Lordship may kindly see
See, presumption operates against you.
he has relied upon that agreement.
Maybe, but why have you not replied? Saying that, see, then you have to face it.
But even if, my lord, I have not given
Then
reply.
the burden on you, rebuttable presumption.
My lord,
You have to discharge that burden.
Bow down to that, my lord.
Yes.
If he relies on that agreement,
Then you should go and face it. Move application.
That is a 6 to 7 then.
He has relied upon that agreement.
Maybe, but you.
Your Lordship may see the deposition, my lord.
Yes.
Your Lordship may see the deposition.
My lord, date was fixed 17 April, my lord.
But the deposition is also there. You cross-examine him.
He is relying on that.
That's right. You have to cross-examine. See, burden is only you to be discharged and a rebuttable presumption. You can't escape out of it.
That my lord, all right.
That's the only thing.
I bow down to your Lordship, what your Lordship says. But that is only mistake that he has not replied. Because they are brothers. There are three brothers, my lord.
The scheme of law is notice is given.
Yes,
that is a statutory notice. It is not a common notice. Statutory notice. And if you don't reply,
I cannot
immediately presumption operates.
I cannot dispute, my lord. I cannot dispute that. And it is a fact that he has also relied upon that agreement.
The court at this stage, taking into the probable defense of yours, cannot quash the proceeding.
No, it is not
That's the
probable
settled
defense,
principle of
but
law.
his case is also that.
Cross-examine him. Knock him out. Rely upon this agreement. He is good for you. That is relying upon.
It is good for me that he has also relied upon that.
That's fine. Fantastic. And now burden shifts on him. You discharge your burden. Onus is on him now to prove the case. So what to do now?
As your Lordship pleases, my lord.
Withdraw and I'll expedite.
Yes, sir.
I'll expedite the trial. Because see, when this complaint was filed, basically?
It is, my lord,
2023.
23, my lord.
Right on. Petitioner is the accused in 1cc case number 242 of 2023, instituted by the opposite party on when was it instituted on? Instituted on 29/9/2023 for earliest commission of offence under section 138 NIA. The Mr. Pal and counsel for the petitioner submits that the check was issued pursuant to a agreement dated 1st February 2022.
May 2020.
No, 20th May, 1st February.
20th May, the check was issued on.
No, I'm talking about the agreement.
The agreement is 20th May. That is another agreement.
Which agreement you are talking about? The agreement you have filed in Annexure 4.
Annexure 3, madam.
Annexure 4, what is that?
3, madam.
What is Annexure 4 then?
Annexure 4 is another agreement that property which is supposed to be sold is now under lease.
Okay.
The 3 years brothers have given that on lease.
Pursuant to the agreement dated 20th May 2022. In terms of the check, the PDCs issued by the petitioner has been deposited prematurely by contravening the conditions enumerated in the condition agreed by the parties in the by the agreement dated 20th May 2022. Therefore, he submits that the complaint is vitiated. It is an admitted fact on record that the notice under section 138 bracket B of NI was issued to the petitioner, which has not been replied by him. Therefore, the presumption under section 139 and section 118 or something, 118, presumption 118,
of evidence that operates against the law and operates against the petitioner. This being a rebuttable preemption, the petitioner is duty bound to discharge the burden. At this stage, Mr. Pal submits that the opposite party is also relying upon the same agreement. He has relied upon the evidence, no? Evidence.
Yes,
Evidence of the deposition.
Which has been executed at Exhibit C.
Evidence of the deposition of the complainant being DW1, who has exhibited the agreements in subject as exhibit C7. C7. Therefore, Mr. Paul submits that since the case of both the petitioner and the opposite party hinges upon the agreement dated 20th May 2022, hence 22, and reading of the agreement falsify the complaint itself. Hence, he seeks indulgence of this court for causing of the entire once is the case. The trial of the case is proceeding at an expected pace. The petitioner admittedly has not replied to the statutory notice. Therefore, it is the presumption operates against him. Hence, it is hence the burden on the petitioner is to rebut the presumption. At this stage, therefore, at this stage, this court is not inclined to entertain this petition. However, regard being had to the fact that the complaint case is pending since 2023, and under the commands of section 143(2) of NI Act, it ought to have been concluded within a period of 6 months. I deem it appropriate to direct the trial court to do well to see that the trial of the case is concluded as expediently possible. With this observation, the petition is disposed. Yes.
Presumption is 139.
No, 139. Yes. Yes.
Item 9. Okay.
This certificate copy you give it. Yes.
Might be yours. The subject matter of dispute relates to the high-ended action of the ED people, I mean agency or enforcement directorate to seize the vehicle of the company and freeze the account, bank account, which are all loan proceeds. I am coming to that. Before that, my lord, short questions arises for consideration whether ED agencies can invoke their jurisdiction under section 17(1)(a) without following the due procedures.
Yes.
The procedure or rigor of law is, my lord, they must give give a statement that this property involves the process of time, and there must be a reason assigned about the involvement of the petitioner. Background of the case is, Lord, this is a case of 2020, and your lordship turn to page 34.
Yes.
At page which is subject matter of challenge. All fine, in the fine morning they came, and 8/1/2025 in connection with ECIRK of 2020 against one Chandrasekhar Samal. He is no way related to my company. And they have not made any endeavorance to find out the link of Chandrasekhar Samal with the petitioner's company, and came and freeze the account of this amount, around 1,10,79,000, along with his own account. I am not concerned with that. I am only concerned with the first part. You will also kindly see page 34. 34.
Yes.
Annex 3.
Yes.
This order was passed under 17(1)(a). The requirement of law, your lordship knows. And it is held by the two reported judgments recently.
what are the requirement to be followed by the investigating agencies. That has not been followed, for which I have come up, Your Lordship.
Now, where is your Sri Monopoly?
Yes,
Private?
yes. In
Sri
fact,
Cons-
Milord, Chandrasekhar Samal is no way connected to my company.
You are Sri Monopoly.
Yes, I am monopoly, yes. But under a presumption or under the pretext that he happens to be the director of my company, in fact, Milord, one of the directors of this
Chandrasekhar Samal
company.
is a director or not?
No, not at all, Milord. I am having the
But
documents.
Chandrasekhar
also.
Samal is director of Sri Construction.
Sri Construction.
Not,
And Sri Construction is accused in that case.
Yes.
And till date, there is not a single.
44 complaint is filed against you, PMLA?
No, no, Milord. No. As
Initial stage.
initial stage, that's all right. But can you, these are all properties I have acquired out of the loan amounts, Milord. I have given sufficient material. If your Lordship permit me, kindly turn to that page 11. This vehicle was purchased.
Which is this schedule offense? Against whom?
No offense, Milord, as on date.
Milord, investigation was initiated against one Ratikant Rao.
Ratikant Raut?
Yes.
Okay.
There are 10 FIRs, more than 10 FIRs against him regarding theft, dacoity, mining scam. So investigation was initiated. And this Chandrasekhar Samal happens to be a friend of that Ratikant Rao. So a raid was conducted on the house of Ratikant Rao. There, these documents were found and the bank accounts were frozen.
No, but what about Sri Monopolies Private Limited? This is a company.
These documents, it's a separate entity.
You might have found out, but what is the link between Ratikanto, Chandrasekhar Samal, anything to do with this company, with these two people?
That, Milord, I have to, because my instructions are, Milord, this Chandrasekhar Samal. In
What have you got from Chandrasekhar Samal house?
Chandrasekhar Samal, Milord.
What document?
We have these bank account documents were found from the Chandrasekhar Samal's house.
See, this is
too much.
This is atrocious. Atrocious.
I cannot.
These are there.
Suppose I travel somewhere.
I agree.
My all documents are kept in somebody's house.
I agree, Milord. Actually, I was
Can't do it.
I have also asked my IO today. Actually, I could not get instructions because apart from the material I found, a vehicle was standing in front of the Chandrasekhar Samal. That has been.
Yeah, I agree.
In my street, if there are four, then the entire street is accused.
That I agree, Milord, but
what is this?
That I agree, Milord, that I have to take
through judgment of the Supreme Court.
No, what judgment is? He also knows the practical problem is they go with doubting everybody. That's the whole difficulty. And if you can have a link with Ratikanto, Chandrasekhar Samal, just see the
Chandrasekhar Samal, Milord, he
maybe but he says nothing. It is a private limited company.
Yes, Milord.
Unless somebody
access to the records. Chandrasekhar Samal, Milord, is the director of the company along with Ratikant Raut in another company. That link
maybe
we have, Milord.
Maybe Sri Construction, no problem.
That link we
I
have.
am not there. I am not against Sri Construction.
Sri Monopolistic Private Limited.
Yes, Milord.
What link this company has with this accused person?
If I call it on Monday, I will.
Okay. Let him get it. If it's not there, then release it.
That's true, Milord.
You are entitled to investigate. No problem. You investigate. No
I
problem.
have enough right to
Yes.
also.
Tuesday. Huh? Wednesday.
I'm appealing the opinion of format.
Yes, their assistance also required, Milord. From my, Milord, these are statutory dues I am unable to pay, Milord. In the month of March, at this juncture, Milord, they have seized my accounts. I am unable to pay my statutory dues even. My employees have not been paid for last 2 months.
Why have you implemented ICICI Bank?
Because the account of mine, which is remained with them, they've actually.
This account is in ICICI
Yes,
Bank.
ICICI Bank. It was transferred to ICICI Bank, current account.
Okay. Yes.
You'll also keep it to Tuesday.
Wednesday.
Wednesday, I have some problem. Tuesday, maybe Tuesday.
Tuesday may not be possible, therefore.
Or Monday.
Monday.
My learned friend was asking for Monday.
Today is Friday, sir.
He'll come and see. He also needs at least
Last time he had
two
taken
working days.
agreement, Milord. I don't mind if Lordship.
He has to seek instruction from
Wednesday.
Wednesday. Let it be then.
Okay. Copy solving.
Give a copy to
Yes,
ICICI.
yes, just now.
Item 10.
May I please, Lord?
Yes.
This case, my lord, I have paid for passing of criminal proceeding only on the ground the delay in investigation. My lord. The prosecution has taken long time to file the charge sheet. They have not yet till
2018.
No, 2017 the FIR.
FIR is 2018.
And
15/3/2018.
At 2025 till today, they have not filed the charge sheet. I have given my lord the opinion of
The Vigilance Department is a record of 10 years.
But I am
It is not.
mere Anganwadi worker. I'm mere Anganwadi worker.
What is the stage?
And but I'm the lady.
Let him get inside.
They're taking time altogether.
Let him get inside. Okay. Issue notice.
Fix up a sort that.
Mr. Mohanan accept notice and seeks 2 weeks time for obtaining instruction regarding the status of the investigation. Yes. 2018 charge sheet has not filed. Where 7 years. If you don't want to file, close it, finish it up. Yes.
Item 12. May I please, your lordship? I am in VC, my lord. My lord. My lord, offense under section 498A, my lord. My lord, marriage held in 2021, my lord. My lord, reconciliation mane chances achi, my lord.
Issue notice, huh? Issue notice. Let me go on short. Yes.
Okay. Deep low, my lord.
Item 14. Please, your lordship. The application of the petitioner under section 91 CRPC to require the opposite party to file the check return memo in a case under 138 NIAC, my lord. I filed an application under section 91 to require the opposite party, who is the complainant, to file the check return memo, because on the basis of that check return memo, the entire case under 138 is based, my lord. However, that application has been rejected by the magistrate, my lord, on the ground that earlier I had filed applications. He has not gone into the merit.
Why are you asking if they have not filed? They have not filed. The benefit will inure to you. Why are you inviting?
Well, they have.
You ask him, answer it. If they have not filed in a complaint in 138, they have not filed a vital document. And you will be getting benefit out of it. Why are you inviting moving application and all?
I raised that objection, and if they fail to, pursuant to that order, if they fail to, that will be beneficial to me, my lord.
Now it is beneficial, it is rejected. In the final hearing, at least you will get the benefit of that. Why are you unnecessarily inviting problem?
If there will be order, there will be order that to file. If they don't file,
what is the order? Let us see.
Tell
me what is that order?
Order is at my lord.
What does it say?
Page number 9, my lord. Page number 9.
9, huh?
My lord.
Yes.
Towards the last part, my lord, the reason of the magistrate, my lord. So the said petition should be rejected. Peruse the case record. It reveals that.
Where are you reading?
The page? Last one, page number 10 to the last portion, my lord. There is a line further. 7 to 8 lines from the end, my lord. Further, one petition under section 91, my lord, 3 petitions were disposed in the single order, my lord. I had filed 3 applications, 3 separate applications. Further, one petition under section 91 CRPC filed by the accused were rejected by this court on dated bar author, and same petition on dated 26/7/19. One petition under section 311 and CRPC read with 19. So the magistrate's reason is that earlier I had also filed section 91 application for different for production of different documents, my lord, not this document. But since I have filed another 91 application, it is a stalling tactic on my part to delay the trial, my lord.
Is correct,
my lord. Even if that is the reason, they might the magistrate should have gone into the merits of this section 91 application, my lord. This can be additional reason, my lord. This can be additional.
I don't understand why have you moved the application at the first instance. Show me the complaint copy.
Well, the complaint is at page number 8. 8,
yeah?
8, page number 8.
8. This is the complaint.
Well, Annexure 1. Well, this is the application, section 91 application.
Show me the complaint.
Complaint I am not annexed, my lord.
Give me the complaint. Let us see what are the document he is relying upon. Let me understand that.
My lord, may I fix it to next week? I'll file the complaint, my lord.
I don't know. Let us see in the complaint he might have given what are the documents he is relying upon at the end.
My lord.
Let me see whether these documents are relied upon or not.
My lord,
If he is not relying upon, he can't prove the case. Why are you moving application for 91?
I'll produce the
Please
complaint.
prove the case against me.
Well, I'll produce the complaint.
Do you have the copy?
I'll
give me. Complaint. He has to prove his case.
Why
are you worried about it? Just what are you asking in 91? Let us see.
Check return memo, my lord. The endorsement from the bank.
Just see the second document. Second document relied upon. Check dated so and so, issued by so and so, intimation slip of the accused banker. That is what you are asking. He has already filed it. He has already filed it. Why 91 then? Let's see the document number 2.
Well, I will get instructions on that, my lord. Whether he's
what instruction? Unnecessary.
He might.
You have not either. You have not read or you want to be smarter enough.
Even my lord, even I have tried to contact him. Whether check return exactly which document he's referring.
See, he relying upon the slip which you are asking in 91.
My lord, I'll just maybe there's a problem.
Banker slip you are asking, that banker slip is relying upon.
My lord. And my lord may keep it to Monday. If that is the case, I will withdraw it.
After 3 weeks. After 3 weeks.
My lord,
not Monday. You don't have a case. I should dismiss right now. But you are asking time. I'm giving.
I'll withdraw it on Monday. If that is the case, I'll withdraw it on Monday.
Better withdraw it. It's good for you. He is already relying upon this court. Trial court has escaped notice and this thing.
Well, I'll get instruction then on Monday. I'll withdraw it. If that is the case.
Yes. Give a date after 2 weeks. Yes. Just check it up. It's not necessary that for every matter you should come to High Court.
Well,
sometimes you invite problem for yourself.
Well, I'm fairly submitting. Well, I'll withdraw it in the next week if that is the case. Well,
better you think of and move an application memo and withdraw it.
Well, I'll withdraw
and concentrate there. Rather, I'll expedite if you want.
Well, keep it on next week. I'll withdraw it.
We will give a date.
Okay. On instruction.
May I please, Lordship, Lord?
Yes.
Item 15, Lord. But the petitioner is the wife of the public servant. She has been prosecuted in the vigilance case under the aid of 109, under the aid of section 109 of IPC, because she was the wife of the.
Let us come to the charge sheet.
Pardon?
Come to the charge sheet. What are the allegations? What is your stand?
Some landed property was purchased in the name of the petitioner.
Yes.
Page 30 direction.
Yes.
Some property mentioned in the description, page 39, those have been purchased in the name of the petitioner. So purely because there stands in the name of the petitioner has been roped in for under the guise that facilitating public servant to.
You are the wife, huh?
Yes, I'm the wife. Only simple Lord under section 107, punishable 109. That is the only allegation and the only material. But there is no statement. No statement of the petitioner has been recorded. That's true, but no statement. No statement has been recorded. By the Lordship, had she interrogated by the police and had she made some defense, then matter would have been different. But no statement has been recorded by the prosecution.
See, the ill-gotten money of your husband, you want to cover it up by putting a separate defense. You have to prove it. 109. You must be relying upon that judgment.
Yes, your Lordship, I'm relying upon your Lordship Sonalata judgment.
That will not.
Where the statement had she been examined, then let the police interrogated and she examined that only the part from the her income starts commencing 10 to 11. But prior to that, prior to that, the property purchase as only on the fiduciary relationship. The check period is commencing from 99 to till 16. So, the statement, had she explained, put up in
page 60.
Madam?
60 at the top. Read.
Assessed in check period.
Similarly, reply.
Yeah.
By letter so from the income tax department, Council, filing IT return of Srimati Sairendri Mohanto, wife of the accused, has been collected and verified, and which reveals that she has been filing IT return since the assessment year 2011, 10, 11, 15, 16 in income tax for so and so, PAN card so and so, so and so. In its return, she has shown income for 19 lakhs so and so from the business against which she has paid sum of so and so. What business you are doing?
That is not
What business are you doing?
business stone quarry.
Then prove it. You have put forth
Defense.
Defense, yes, to justify the ill-gotten money of your husband.
This has been collected by the police, but no statement of the petitioner has been done.
No, that is not a requirement. Oh, they are relying upon the income tax return.
Yes.
So you are holding some lease. Are you holding some lease?
No.
Quarry lease?
No.
What business you have then?
Stone quarry, stone crusher.
Where have you? Do you have a license in your name?
The license, license, but the investigating.
All these things has to be proved in the trial only. Where is
that has not been because nothing brought by the investigating agency. That's my submission. Because things which has not been gathered by the investigating agency. Therefore, I am humble submission that the 1:1 statement should have been recorded.
It's not necessary. Are you suggesting that since 161 statement of accused is not recorded, therefore the charge sheet has to be filed? That's what your case.
Defense. Because had I pleaded in defense.
So at this stage for filing at the time of filing of charge sheet, the defense has to be recorded. The accused statement and everything has to be recorded. They are relying upon the income tax return which you are filing. You have to justify it. You have to justify it. That is the 109 is enough.
I will bring
you are directly directly against you.
But I am relying upon Lordship Sonata.
I have distinguished that judgment by another judgment.
Milord, I will
read this judgment.
But next week, Milord, I will bring the income tax return.
You just see the judgment and read it. And next judgment,
Anuradha, I have gone through.
Read it. I have distinguished that.
Your Lordship has delivered 2 judgments, one in Sonata. Milord, I will income tax. Let it come next week. I will bring the income.
Okay. After 3 weeks, yes. Next.
Item 70.
Milord, in the meantime, Milord, I will make the book.
Do whatever, but
Yes.
you don't have a case.
Milord, income tax. I am conscious, your Lord. Your Lord will deliver 2 judgments.
Read both the judgment, you see.
Your Lordship has delivered 2 judgments.
Yes.
In another case.
Yes.
In this case, the petitions being agreed to the order of Mr. Bhadra on Annexure 77 have moved this Hon'Ble Court praying for passing of this order. Meanwhile, what happened? This opposite party number OP, who is a stranger, he made an application against the petitioner and sought for an initiation of 144 proceeding in the court of SGM Bhadra. And he alleged that two plots have been forcefully occupied by these petitioners and they are raising construction over the same. He is a stranger and these petitioners have been occupying these lands for the last 39 years. The property belongs to a matha. And we have been possessing the same with the due permission of the authority. We are paying rent to the matha, and for the last 40 years, this is the position. And we are having a thatched house or tin house. There are over the same plot. Out of 2 plots, 1 plot is under occupation. The rest plot is under the occupation of another person to whom he has not made party. After entering appearance in the said case, under Annexure 2.
What is the order then?
Under Annexure 2, your Lordship can see at page, under Annexure 2, page 22.
Yes.
Your Lordship, page 22.
Yes.
This is the order of SDM, Bhadra. 2 plots are there, and the status quo order was granted by this order, and direction was made to IAC Bhadrak to promulgate the order on the spot from the order of the party and return the SR or before the next date fixed. The IAC Bhadrak is further directed to cause an inquiry into the matter and submit report regarding breach of peace over the spot or before the date fixed. Thereafter, the Northern Bhadrak is also directed to cause an inquiry in the matter and submit a factual report on the date.
Where are those reports?
Below, these reports have never been disclosed to the petitioners, and those reports have been relied upon by the court below. And this is the basic law that if at all you are using those documents should be laid bare. That should be confronted.
Where are these? The reports are there with you.
Those documents are not. That is official records. Those documents are called for the government officers by the regime, and relying upon those documents, ultimately he converted the proceeding to 145 in spite of the fact that we have been possessing the property for last 39 years. And against this order, we filed.
So what, then you are agreed by which order? Basically?
Annex 7. That is the order.
Let us see the last. What is the operating part?
Yes, Miller. Para last 14, page 42. Miller.
Come to page 42, para 14.
Miller.
Read para 14.
Paragraph 13 may kindly see that is also.
Come to 14. 14 is the operating part. Yes. Section 145 CRPC order is a temporary order. Yes.
In a proceeding under this section, the merits of the claim of any parties to a right to purchase the spot of dispute cannot be decided.
Yes.
When at the time of passing the final order under section 145 CRPC, the Lorraine court below has clearly mentioned that dispute a plot stands record the name of Sri Gopal Ju Gosara and the petitions is the secretary of the charitable trust, and the opposite party are staggered the proceedings and forcibly include the entire land stated construction over the same, being the opposite party and government servant who is money and influential person trying to disperse the petitioner, and when there is every apprehension of breach of peace as regards to the possession which may lead to law and order situation at any time over the spot, convert the proceeding into 145 CRPC is neither unreasonable nor the same will erroneous. When the input order is not unreasonable and for the reason stated above, then at this juncture question of indifference will be.
What is wrong in it?
My submission before Lordship is that the Lorraine court below heavily relied upon the two documents. The report.
What is the life of this order?
Those documents.
What is the life of this order?
It's
not a permanent order.
144, that proceeding was for 2 months. Thereafter,
there was a breach of peace and the court has intervened.
Breach of peace, whether in fact that document was disclosing there is a continuing breach of peace or not.
Why don't you settle the dispute?
This person who initiated the proceeding, he's actually absolute stranger. He's no way connected to the property. And another person who is occupying the property, he's not made a party. If at all, he's expounding the cause, he's expounding the cause of the property.
Okay, I'll issue notice, let us see. Issue notice. Yes, next. Okay.
I'm challenging I filed this application for posting of the affair. That case, your lordship, the other two cases were, my lord, other two cases were filed by the freezing of accounts. This gets related to that, my lord. Your lordship may see first what is the affair, my lord, at page 24.
20?
Page 24.
What is the stage now?
My lord, the case is still under investigation. No charge sheet has been filed. What is the background of the case I'm saying, my lord? This is this petitioner has joined the Falcon Marine in 2004, and he was the person who was the responsible for the growth of the Falcon Marine. Like he tendered his resignation in January 24. After his resignation, they have filed this false affair, and did not also give him the release order so that he cannot join anywhere. In spite of that, he joined in a good company, my lord, and now he is there, my lord. Now there behind him, why did you leave our company? Because he is the person who is the, my lord, expert in marine export division, my lord. And now they have, my lord, when all the moment, my lord, I got an interim protection from this honorable court, they froze my account. The police officer froze my account and before registration of affair, they had given a notice for, my lord, search and seizure, which I have come before this honorable court. This honorable intervened, no, you cannot do that, and release him under 41. Thereafter, they registered this affair. Your lordship sees what is the affair, what offense money is made out. I am reading the affair, my lord, first.
Yes.
My lord, what has happened, my lord, background of the case, my lord. In the year 2023,
you were working in this company as what?
CEO, Chief Operating Officer. I have rendered my resignation in the month of January 24, my lord.
Okay.
24. And the allegation was this, if this allegation is also true, my lord, this has happened way back in 2021-22. What has happened, my lord? During the course of investigation by a income tax department, some bogus transactions were found to be in the books of the accounts of Falcon Marine, my lord. That was investigated upon, and these two persons whom they have alleged to have made the payments, they were called upon and they deposed before the income tax department that these were for our own purpose. This has nothing to do with the company. I'm reading the, my lord, what is the allegation? During course of income tax investigation in June 2023, he is dealing with the various suppliers were questioned, and it was found that Mr. Pradhaman was indulging in corrupt practice for his individual gain, causing loss to the company while in employment. It was found that he was taking money from the company's suppliers and instructing them to make payment to various persons to discharge his personal liability. The following instances came to our notice, madam. 1. During the period from November 21 to March 22.
So these are the fraudulent transactions you have indulged into.
I have not
when you have been confronted, all of a sudden you resign in 2024. That's what the case.
That is their case, my lord. Because but these I have not made any payment. The persons, my lord, these two persons.
How will I know at this stage? Let it be investigated.
Well, I have.
You are being protected. No problem.
I have been protected.
How can I stall the investigation of this nature?
This is not the one issue. Another issue, my lord. I have also made a representation to the police that this was investigated by the income tax department. And
I will direct the police authority, investigating authority, to take into consideration everything and deal with.
And another aspect, my lord. This affair has been lodged in 25.
Yes.
I resigned in 24, my lord.
That's what their case is. When in 2021 and 22, when you have committed this thing, when they confronted you, resigned.
I resigned and they filed the affair in 25.
Maybe.
And the affair has been registered in the IPC. That is also my one of the ground, madam.
See, after the charge sheet is filed, they may invoke the right provision. Let it be investigated.
The act has been, the IPC has been repealed. And also the saving clauses doesn't say that if the offense is committed, it will be registered under the IPC.
I can understand if these offenses are taken from the book. Only sections are changed. It doesn't mean that the entire offense goes. In place of 406, some other section.
Yes.
Verbatim same. And the police are not.
My only grievance, my lord, that they are not taking the documents from the income tax authorities who have done an investigation on this issue and they have closed this.
And I will direct
that part, your lordship, direct.
I will direct the investigating officer to take into consideration everything which you have raised in this point. In this petition. And deal with that in right.
That will, my lord.
Petitioner is seeking indulgence of this court in the present.
I have given that representation under annexure. I have given the details. Annexure 7. That we call for the documents for income tax department.
528 of BNSS. BNSS for causing of the Lakshmi Sagar PS case number 19 of 2025. The investigation of the case is at the nascent stage. The Mr. Paul, the counsel for the petitioner, attacked the seeking quashing of the fire on various grounds. Primarily he contended that the income tax. What do you say? Income tax?
Income tax authority have conducted an investigation on this.
Primarily contended that the
and they have closed
relating to the complaint, the income tax authority have already investigated into and exonerated the petitioner. The investigating officer is not taking into consideration those aspects of the matter. Apart from that, he submits that the FIR is registered on 18/1/2025 for Ellis Commission of Offences under Indian Penal Code, which has already been repealed by BNS. BNS. I am since the investigation is the nascent stage. Although I'm not inclined to entertain this petition, however, liberty is granted to the petitioner to place before the investigating officer the present petition. The investigating authority shall deal with all the contingent raised by the petition and take into consideration and deal with the same in accordance with law while filing the final report, public final form, public report under section 173 of CRPC. Yeah, CRPC means change 173 CRPC for BNS. BNS is again you have to see constantly. That's the problem.
Even if, my lord, the entire prosecution study is believed, no, I have not made out, no offense is made out, my lord. On plain reading of the FIR, my lord.
193 BNS. 193 BNS, bracket to 173. Okay. Okay. Yes.
20. One more line, my lord. Can I pray, my lord? I'll produce the certified copy to the, my lord, investigator with a representation. They will take care of that part.
That I have said. That I will modify that part.
The petitioner challenge the against the before the approach before the Hon'Ble Court, my lord, quashing of the criminal proceeding, my lord, under section as L 376 2N 420 313 506 323 of 34 of Indian Penal Code, read with 32V of SC and ST Prevention of Atrocity Act, and also 6 of the POCSO Act, my lord. I also made as a party victim, also opposite party number 2 as a party. My lord, my humble submission that, my lord, the prima facie the case has not met out against the present person. Bare perusal with the FIR, my lord. The victim is aged about 20 years. She has mentioned in the at the time of occurrence, my lord.
Charge sheet has been filed.
My lord, charge sheet has not been filed, my lord. My lordship, call for the case date, lordship, so that lordship, I pray, my lord, call for the case date, whether any further proceeding, my lord.
Wait for till the charge sheet is filed.
My lord, though, my lord,
obviously charge sheet will not be filed on POCSO.
My lord, another aspect, my lord, 3 SC Act was not made out. My lord, so far is bare perusal of the FIR, my lord. She has categorically stated that when she and the present petition reside in the auntie's house, my lord, then the victim, the present petitioner scolded the name of the caste of the victim, my lord. So it is not a public, as for mention, my lord, so far as decision is concerned, my lord, it's not a public view, my lord.
So
though
all these things, investigation is still going on.
My lord, lordship, my
the
case is, my lord, the case is registered 14/11/2024. My lord, perhaps, my lord, the case something the investigation,
whether charge sheet is filed or not.
Let them instruction, lordship, my lord.
Issue notice, Mr. Vishal accept notice, and to Mr. Vishal seeks time to get instruction regarding the status of investigation. Yes.
I pray, my lord, till that course of action.
No. This is
my lord.
I will dismiss it. Basically, you have to go and tell the IO whatever you want to tell. Yes.
21.
My lord, may I please, your lordship? Lord, prayer for quashing of FIR on the ground of compromise, my lord. Offenses under section 294, 34, 341, 354, 4.
What are the allegations?
मतलब 420 मतलब informant already been
What have
appeal.
you done?
मतलब already been मतलब क्या matter has been settled my lord. Both the parties are present my lord.
What have you done? Let us
My
see.
lord, yes my lord. My lord, allegation my lord, the informant my lord working as a manager in a automobile shop my lord and invested 21,74,763 for development of the workshop my lord. My lord, already my lord, money has been already been my lord say get back her money my lord and matter has been compromised my lord. Parties are present my lord. Informant has already been present and I filed the affidavit in this regard my lord.
Yes, some monetary dealing. The entire money has been
Entire
released.
money my lord, affidavit my
What
lord.
is the stage of investigation?
The charge sheet filed my lord.
Except FIR, you have not filed anything. Where is the charge sheet? What has come against you?
Charge sheet, I have not filed my lord.
How can I quash like this? I don't understand.
My lord,
Except FIR, you have not filed anything.
Informant present.
What are the offenses you don't know?
Offense are 420.
In FIR, what is in the charge sheet?
Charge sheet my lord, 420 my lord.
I am just surprised. How can this kind of petitions are being registered? Where have you said the charge sheet is filed? Where have you said anything? 2-page, 1-page petition. Quash it. We have settled. No annexure. How these petitions are entertained? I am just surprised.
Next week my lord.
The allegation is 21,74,763 rupees you have taken from him. Molested, abused, everything, all allegations are there.
Money has been paid my lord. Money has been paid.
Money paid, but what about the charge sheet? Whether it is 354 or 376? How do I know?
Next week my lord, I will file.
What next week? Withdraw it.
No, my lord, sorry, my lord, next week, my lord,
I'll dismiss it with heavy cost. I'll take.
Pardon, my lord.
Court should not have entertained this kind of petition.
Pardon, my lord.
Not at all.
My lord, I'll file, my lord. Next
Don't
week,
pardon the court like this.
Pardon, my lord, I'll file, my lord.
Seeks to withdraw this petition to file a better one. I'm giving that opportunity. Better one with better particulars and the relevant documents. And list it. I list it next week. File it. Press one. There is nothing. 1-page petition without any document, without anything. Where you said the settlement. Where is the affidavit of settlement?
File, my lord.
Where have you said that settled? What are the offenses? Nothing is written.
I'll file, my lord.
File a better one. Attach that affidavit and file a better one. It can't be entertained like this, right? Petitioner seeks to withdraw the petition with liberty to file a better petition with better particulars and relevant document. Let him do so within the petition is disposed of. Dismiss is withdrawn with liberty expressed. File it and mention it. I'll take it up next day. Mention it. Okay. Take it, annex this. What you call the affidavit in the petition. Charge sheet, when charge sheet is filed, if you don't have a copy of charge sheet, at least make an averment in the petition. Charge sheet is filed for offense so and so. At least that averment should be there. Then I'll entertain and come and mention it. Okay.
22.
Remind me that I have filed it. I have withdrawn and filed it so that I can mention, entertain it. Okay.
22.
May I please, your lordship? Lordship, the petitioner is the complainant
and also settled. Petitioner and victim married.
Married.
Your lordship, 22 arises out of a check bounce case, your lordship. Item 22 arises out of a check bounce case, your lordship.
Okay.
Your lordship, the petitioner is the complainant in a proceeding arising out of Section 138 NI Act.
You are agreed by the order dated 14/8.
14/8/2024
What
under
is this
Annex
order?
6 at page 43, your lordship.
Yes.
Lordship, the learned trial court, without considering our objection and by not whispering anything about our objection and only by passing a non-speaking order, has allowed the petition under Section 294 CRPC filed by the accused opposite party. Your Lordship, the facts in the present case is that the check was issued by the accused opposite party as proprietor of Sagarika Marine Engineering. Therefore, and then after, due to dishonor of when the check was presented in the bank and was returned with endorsement that funds are insufficient, the present petitioner, he issued a notice to the accused opposite party.
Yes.
Your Lordship, in the reply, the accused opposite party has stated.
I'll issue notice.
Your Lordship.
Issue notice.
And
nothing is written in the impugn order.
Yes,
despite your objection, detailed objection.
Objected to the genuineness of the document, which has been sought to be produced.
And the application is also vague application.
Your Lordship.
Rather, your reply to the application is more detailed.
Your Lordship. Without whispering anything about our objection.
Page 36 is the application.
Your Lordship.
And your reply is next page.
My reply is at page
much
39.
more detailed. Much more detailed.
Your Lordship.
Yes, issue notice.
Your Lordship, an IA is there for a stay of further proceeding because
this is a complaint case. Why are you asking? You are a complainant. Why
Your
should
Lordship,
you
what has happened in this case? The
I'll stay the impugn order. Operation of the impugn order.
Your Lordship.
I'll not stay the proceeding because you are the complainant. Why should I stay?
Because our arguments are already over. We have closing arguments are from the side of complainant are over. The memo of citations were served. On the next date, they filed a petition totally changing the nature of the case, Your Lordship. That these documents.
Then I'll stay the operation of the impugn order.
Your Lordship. Now
Okay. Then what will happen if I stay the operation of the impugn order?
Sorry for intervention.
Lordship may stay
Obviously,
the operation.
I'll stay the
Your
operation.
Lordship.
When it comes for the petitioner, the petitioner is the informant in 1cc case number 357 of 2015. See, 2015, this is pending.
Your Lordship.
2015. The trial of the case is prolonging since last about 10 years. 10 years. When the matter was the matter was taken up for when the complaint case was the fake end of at the concluding stage. At that stage, the opposite party accused moved an application under section 294 CRPC inter alia seeking
The prayer to adduce.
what is the direct the
Their prayer was to allow the accused to be re-examined and to produce relevant document. Produce some relevant.
Read the prayer.
Your Lordship, the prayer is at page
36.
38. Page 38, Your Lordship.
38,
Your Lordship.
yes.
Annexure 4 at page 38.
Yes.
It is therefore prayed that Your Honor would graciously be pleased to allow re-examination of W. Justice Malik.
Prayer. Continue.
When the complaint is for the concluding stage, and that is the occupied accused moved an application with the
Seeking re-examination of DW1. That is the informant, complainant.
Your DW1 is the accused, Your Lordship.
DW1, DW1, once again, and sought to produce additional documents, relevant documents, produce relevant documents, documents. The trial court, while the impugn order dated 7th,
14/8/2024.
Impugn order dated 14/8/2024 allowed the application without assigning any reason. Relevant would be to reproduce the impugn order, page 43. Page 43. Page 43. And counsel for the petitioner submits that despite the detailed objection filed by the present petitioner to the application moved by the opposite party under section 294, the trial court allowed the application without assigning the reasons. Issue notice to opposite party written also. Operation of the impugn order dated 14/8/2024 passed by CM come JMFC Pujongo in ICC case number 357 up to 2015 is stayed. till next date appearance. Yes. Yes.
23.
The petitioner before my lords is one Manoj Kumar Das, aged 26 years old, and his father and his father's friend, and that petitioner number one's friend, my lords. Allegation is that
What do you want now? Passing?
Lords, not questioning on basis of this. Lords, what I want is the matter may be sent to mediation. I have made the mother.
What is happening? If investigation is going on, I can't send it to mediation.
Lords, it's an FIR of the year 2020, June 2023.
What is
the offenses are 363, 366, 109.
I understand. I've seen it.
Presently,
What is
the petitioner and the victim are married. They are major. Lords, may kindly send it to mediation so that it can be settled between the parties. This is all I'm requesting.
Why should court be a party to this, all this thing? I don't know.
Because it's the girl side, she's a major, she is married.
Then if they are settled, then file affidavit, come here.
The girl's family.
Why should I be instrumental in getting? Then you go and say that court has asked me to settle.
Milords, make the recommendation, Milords. It's the girls' families. They have not filed the charge sheet yet. It's a matter of June 2020.
Where have you said that charge sheet has not been filed?
No. It has not been filed.
Show me. Where have you said that charge sheet has not been filed?
They have not stated it.
Not stated, Milord, because charge sheet has not been filed.
Except FIR, you have not filed anything. If
I don't have any other document in the case,
you
Milord.
tell me one thing. If investigation is going on in such a matter,
Milords.
allegations are so serious.
Milords.
Can I open another parallel the form mediation?
Milords,
Investigation is going on.
Milords,
I will start mediation.
Milords, there is no 376 in the matter. It's only 363 and 366, Milords.
It's very minor offenses.
I'm not saying it's minor offense, Milord, but
if investigation is going on, how can I initiate a mediation?
Milords, the girl and
superseding investigation.
The girl and the boy are married, Milords, as of now. If they go to mediation, if they can't settle, they will come back to us.
For the petitioner seeks to withdraw this petition to file a better petition with better particulars and relevant documents.
Milords, I don't have any documents in the present case.
With liberty as per. File joint affidavit and come and say proof of marriage, something.
Milords.
One FIR, one page, slip, pass it. What kind of petitions you people are filing? It should be dismissed with heavy cost. Some semblance of something, you know. They married when they married. What is the stage of the investigation?
I have.
What is the proof of marriage?
I've submitted that in my petition, Milords.
Where is the proof of marriage?
Proof of marriage I have not.
Then? And you say that you call them. Then you go and tell that court has asked you, come and make a statement.
The girl and the boy are living together.
Why should the court be a party to your settlement? You really settle, then come and tell us with proof.
I'll do that.
Yes, do that. And with all relevant documents, you make evidence, joint affidavit and everything placed on record. Then it will be considered. Okay. And mention it thereafter. Okay.
24, my lord. May I please, my lord? Item 24.
Yes.
May I please, my lord? My lord, here the petitioners challenge the order of issuance of warrant of arrest under Annexure 4 series, my lord. What had happened is actually, my lord, proceeding under section 126, which is 107 CRPC, was initiated against the petitioners. Consequent upon which they appeared, filed the so cause, which was not accepted, and they were directed to execute the bond. Your lordship would find it at page 23 of Annexure 3 series.
How many orders you have challenged in this proceeding?
The main order 11/3/2025, wherein warrant of arrest is issued, and the previous orders, your lordship, which is ranging from.
Show me the last order, 18/3.
Yes, page 30. Page 30, your lordship, 11/3/25.
That's the last order.
Thereafter, another order was passed. I filed an application for recall of the said order. That was also rejected. Only ground was stated that not satisfactory. The so cause was filed. Throughout, what had happened, if your lordship would please to see, your lordship, I have executed the bond as per the direction of the learned magistrate. Thereafter, as per the DR report, your lordship may kindly have a glance for a moment to page 27. Order dated 25/2/25.
Yes.
The second paragraph, it goes like this, Your Lordship. It is a clear violation of the violation of the bail bond. As it appeared, last three lines, Your Lordship, as it appeared that such breach of peace cannot be prevented.
Where are you reading?
Page 27, second paragraph, last three.
It is a clear violation of the bail.
Yes. Unless a warrant is issued against them as required under section 132. I pause here for a moment, and Your Lordship may kindly have a glance to section 130 for a moment, Your Lordship, of BNSS.
132, yes.
130, prior to 132, Your Lordship, 130.
140.
130.
Yes.
130 is order to be made when a magistrate acting under section 126, 126 is 107, the present proceeding from which the present proceeding arises, Your Lordship, deems it necessary to require any person to show cause under such section, he shall make an order in writing setting forth the substance of the information received, the amount of the bond to be executed, the term for which it is to be enforced, and the number of sureties after considering the sufficiency and fitness. Now, Your Lordship may kindly have a glance to section 132.
Yes.
Section 132 provides, if such person is not present in court, pursuant to the order of 130, if that person is not present in court, then section 132 comes, Your Lordship. The proviso clause says, provided that whenever it appears to such magistrate upon the report of police officer or upon other information that there is reason to fear the commission of breach of peace, and that breach of peace cannot be prevented otherwise than by the immediate arrest of such person, the magistrate may at any time issue a warrant for his arrest. I put a full stop here, Your Lordship. Your Lordship may kindly have a glance. The section 132 is a preconditional procedure, Your Lordship, prior to execution of bond.
Yes.
If Your Lordship would please to appreciate, 132 is a provision which is a preconditional procedure prior to execution of bond.
Come to the point, why are you bringing so many provisions into it? How are you aggrieved, you tell me?
Because the warrant was issued under section 1.
Warrant, I'll stay the warrant, go and appear. As simple as that. Why are you bringing so many sections, this, that?
It is to
go and appear and say whatever you want to say. Where is that order? Warrant.
Warrant order.
Warrant is issued. You had given a bail bond of 10,000 rupees. Right. You appears to have violated. Therefore, warrant is issued.
That's
go and appear and say, as simple as that.
If Your Lordship would permit me for a moment, Your Lordship.
No, don't bring. You tell me which is the order. I'll say it and go. Appear.
Page 30, Your Lordship. I have ventilated that. Also
30, 130, 30, 30.
30.
Yes.
I have also state. It was also rejected.
You have violated the bail bond conditions.
That was on the basis of the DR. We were not given a chance to examine, Your Lordship. Your Lordship allow us to
is agreed by the order dated 11/3/2025, passed by the executive magistrate, directing the IIC Damanjuri to execute the arrest warrant and produce the petitioner before the court on 18/3/2025 for having violated the bail bond executed by them, petitioners, by them before the court on 19/2/2025 to prevent the breach of peace. Mr. Panigirai, learned counsel for the petitioner, taking me to the provision of 130, 132 and 139 of BNSS. BNSS submits that the order passed by the executive magistrate is not sustainable under law. Sustainable. Have you moved an application?
Yes, Your Lordship.
Where is that application?
Your Lordship would find it at page 31.
21.
31.
31. 31.
Yes.
31.
submits that he had moved the application before the executive magistrate for recalling of the order under section 139 BNSS and submitted under section 139 BNSS to appear and file the so-called notice, which has been turned down. Without adverting to the details of the argument advanced by Mr. Panigirai and getting into the merits of the case, suffices to say that the petitioner, the impugn order dated 33, impugn order dated the operation of the impugn order dated 11/3/2025 is stayed, and the petitioner is granted liberty to move fresh application before the executive magistrate Koraput, raising all the points. If such application is moved, the magistrate shall deal with the applications and pass a reason order. With this observation, the petition is disposed of. Yes, I have stayed the proceeding. You move fresh application, the magistrate will deal with it.
Grateful, my lord. Deeply.
I pass the detail order. Yes.
May it please the lordships.
Yes.
The petitioner here challenges the order dated 27/12/2024, wherein they have filed a petition under section 205 ARPC to dispense their personal appearance before the learned court below. The same has been rejected by the learned court.
Now that
yes,
the same thing.
Go appear, yes.
Go and appear.
Why he filed 205? I am unable to understand. If he have gone there, filed an application, that could have been
withdraw it, file it.
Withdraw
the same thing, na? What is that?
That
same law. When counsel for the petitioner is agreed, the petitioner is agreed by the order dated 27/12/2024. Where is that order?
We have appeared there, my lord.
A1 2024, whereby his application under section 205 CRPC has been rejected. In view of the judgment of the Honorable Supreme Court in Tarsem Lal
versus Directorate of Enforcement, reported in 2024 7 SCC.
Then counsel for the petitioner seeks to withdraw this petition to approach the trial court, relying upon the judgment.
Yes, I am already appeared before the honorable court. I have filed the petition 88 CRPC bond as per the provision of Tarsem Lal. Thereafter, on the date of charge, I was also present. Thereafter, I have filed a petition under section 205 to dispense the personal appearance as per the bond. That has not been taken care of by the.
Then, as and when you require,
yes, sir. Yes,
that order
as and when required, I will appear before the honorable court.
Withdraw pursuant to the order dated in the light of the judgment of Tarsem Lal also, he has already appeared before the court and furnished the bail bond.
Yes, furnished the bail bond. In the date of charge also, I was present.
Bail bond. Subsequent thereto, he has been appearing before the court
in each and every date.
Your lordship may call.
However, his application when the trial was proceeding, at that point in time, he moved an application under section 205 CRPC, which has been turned down by the impugn order dated 27/12/2024. He is agreed by the same and assailing the same by filing the present petition. I will simply say that as and when required, he will appear.
Yes, may call it on next week, my lord, because I have to take instruction. If my friend is saying whether he has appeared or appeared through lawyer, I have to verify. Lordship, call it next week because
I will record his statement. What I'll do is I'll record his statement that he has appeared.
Till date,
taking into consideration that I'll simply say that as and when required, he will appear physically.
Yes, ma'am.
And the rest of the time, we move application.
The trial court has held, my lord, no material, no document was filed that is unable to attend the court. Simply filed an application. Your lordship, kindly see page 18.
18, yes.
Para 5, page 17. Personal criminal trial is normal rule and exemption is an exception which can be resorted to in a suitable case by due exercise of judicial discretion. The accused witness have put forth her personal inconvenience for the ground to dispense with their personal attendance under section 205 CRPC it is submitted that the accused petitioner number one is a government servant staying in Hon'Ble and the petitioner
And
number two.
Kotak.
So your lordship, I call it next week, my lord. I will take better. It will be better, my lord.
Simply issue notice. Issue notice. And you just said we can dispute it.
Otherwise, I could have said that's why.
Sir, I am personally present. I am the conducting counsel in the lower court. In each and every date till date, I have appeared in this.
But it has to reflect the order.
Yes,
the order creating the order creating.
Otherwise, trial court will be misunderstood.
I'll just simply issue notice. We'll clarify that, and as and when required, you will have to be present. And the rest of the time, 317
CRPs
and VC. Both the things you can.
Yes.
Yes. The idea is to the trial has to go on.
Yes,
That's all.
yes,
Your presence should be there. That's all. Yes. I'll take it up at 2 o'clock. I'll take it up. Yes.
Plus for item 6.
Non-APS for the parties, even on the second call. In the interest of the case, up to 4 weeks. At least the matter up to 4 weeks. Yes.
Item 33.
Yes.
Like the lawsuit. The lawsuit petitioners challenging the order of coordination taken against a petitioner. That is Annex of 3.
Use the mic. I can't hear it.
Annex of 3, running page 57. The order of coordination is under challenge. The lawsuit kindly glance the FIR lawsuit. The FIR lawsuit, that is running page 19, the written report.
Come to the charge sheet.
Lawsuit. Thereafter the charge sheet is submitted. I also filed the entire document lawsuit. Firstly, see the FIR lawsuit.
After FIR, charge sheet has come.
Let
us see what are the allegations and what has come against you. Reena
Saul, present petitioner is working as a secretary in the primary property society. Has kept the urea sar, 50 bags of urea sar and other liquid urea in a different place without prior permission of the president and secretary, which is the authority under the law of the under the Cooperative Society Act. That is the allegation in the presentation.
As per the
without beyond the knowledge of the president and secretary, which is required under the law, has kept the 450 bags of urea in different places without the knowledge. Only to misappropriate the 450 bags. That is the allegation.
I am coming to that one. The secretary of the president of the concerned cooperative society has been examined.
Yes, I got it.
Lordship. That is only page 46, Lordship. The statement of the president of the concerned society secretary. Lordship, got it? 46, Lordship.
Yes. Read it.
Lordship. ମୋ ନାମ ସୋ ଆଜି 18/23 ତାରିଖ ଦିନ ପୋଲସରା ଥାନାର ତଦନ୍ତକାରୀ ଅଫିସରଙ୍କୁ ଦେବା ମୋର ବୟାନ ହେଇକି ଯେ ମୁଁ ପାଣ୍ଡିପଡ଼ା କୋଅପରେଟିଭ ସୋସାଇଟିର ସଭାପତି ଅଛି। ମୁଁ ଆମ ପାଣ୍ଡିପଡ଼ା ପଞ୍ଚାୟତରେ କୋଅପରେଟିଭ ସେକ୍ରେଟାରୀ ରୀନା ସାହୁଙ୍କୁ ଭଲ ଭାବରେ ଜାଣେ। ପ୍ରତିବର୍ଷ ଆମ ପଞ୍ଚାୟତକୁ ଜଗନ୍ନାଥପୁର ମାର୍କେଟ ଫେଡରୁ ସାର ଆଣି ଚାଷୀଙ୍କୁ ଦିଆଯାଏ। ଏହି ବର୍ଷ ସାର ରଖିବା ପାଇଁ ଆମ ପଞ୍ଚାୟତରେ ସେକ୍ରେଟାରୀ ରୀନା ସାହୁ ଅନେକ ଲୋକଙ୍କୁ ବୁଝାବୁଝି କରିଲେ, କିନ୍ତୁ ବହୁତ ଲୋକ ନିଜର ଘର ଭଡ଼ା ଦେବାକୁ ମନା କରିଲେ। ତେଣୁ 27/9/2023 ସେକ୍ରେଟାରୀ ରୀନା ସାହୁ ଜଗନ୍ନାଥପୁର ମାର୍କେଟରୁ ସାର 2 ଗୋଟି ଟ୍ରକ୍ ଦ୍ୱାରା ଆଣି ଆମ ପାଣ୍ଡିପଡ଼ା ପଞ୍ଚାୟତରେ ଜାଗା ନ ମିଳିବାରୁ ସେ ସେହି ସାର
What about the other evidence?
Other witnesses, Lordship. Then Lordship, come to run page 41, where the fertilizer was stored. Lordship, got it? 41.
Who is this truck driver? No, truck driver. Brundavan, sir, Sabato.
running was 41 lakhs. Before the
Panchayat re jagar nathibaru.
lordship. It is between the knowledge of the president, and they have to take the house on the rent basis, and then no bag has been misappropriated.
All drivers have said that. Yes, what do you say?
Lots of I am reading the one statement of Ranjan Kumar Sahu, who is the circle president of the circle. President of the circle, Your Lordship.
No, Ranjan Kumar Sahu is separate. He is not the president of the concerned section.
1 minute, let him please. I understood it. See, the truck drivers, those who have carried, they have said that since there is no place there in the what is that poda? Pandi poda. So therefore, they are taking this on the instruction of Rina and the arrangement. They are taking it to different place to park it.
Yes, I am not.
That's what.
That, Lordship, one statement I am reading.
And the president also says that.
Yes, Your Lord.
Yes.
But the present petitioner Ranjan Kumar, President
Yes.
Ranjan Kumar
Yes.
Sahu, who is this president of the circle of that area, Your Lordship,
Yes.
has clearly stated that mu ajita 27/6/2023 दिन मास्पेट जगन्नाथपुर 2 गोटी ट्रक जहाज नंबर सो एंड सो जोगे 450 गोटी यूरिया सार बैग जगन्नाथपुर रु पांड्यापड़ा पठा जायतला किंतु ताहा चिरिकपड़ा शासनर तुम्भेश्वर रोड रे अवस्थित सरोज कुमार स्वाई गोदाम घर ठारे मते न जणाई
तांकु कोन
अनलोड कराई तेणु मु आज कोऑपरेटिव सोसाइटी को ब्रह्मपुर रे डेप्यूटी रजिस्ट्रार को विश्वरंजन सार को जणाइथिली under this cooperative societies act, Your Lordship, that is required under the law to prior permission is required to obtain to keep the different places.
Come to page 41. Saroj Kumar Swai.
Yes,
Read Saroj Kumar Swai.
Yes.
Read it.
Yes, Your Lord. मोर नाम सरोज कुमार स्वाई सोन से वॉइस ऑफ डिप्यूटी शासन थाना पुत्र जिला मो चिक्रीपड़ा साही स्थित मोर निज घरे मोर पिला छुआ मान को धरी रहउची मु आम ग्राम तुम्बेश्वर रोड रे 2 कोटी गोदाम घर अल्प दिन ला तयारी करछि गत 23/2023 को दिन पांड्यापड़ा कोऑपरेटिव सोसाइटी सेक्रेटरी आसी अनुरोध करी कहले जे आगामी चाष समय को दृष्टि रखी अधिक यूरिया सार चाषी आवश्यक रहउची किंतु ठीक समय सार जोगई पाउ नाहंती तेणु मु अधिक सार आणुची किंतु पांड्यापड़ा रखिया पय पर्याप्त जगह नाही किबा कोनोसी लोक सार रखले घर नष्ट होई जे बोली भड़ा रे घर गउना तेणु तुमरो दुईटी गोदाम भड़ा ने जे that is the
Then what is the case?
Your Lordship, here is the
president says that there is no place.
Yes.
So therefore the urea and everything has to be placed somewhere else. Two driver, those who were taking the stock, they themselves have said that the Rina and arrangement say that there is no place here. Go and we have hired a place. Please park there. And the person who has rented the go down, he says that on the rent of how much?
450 bags of urea.
Yes. He says that on the rental basis, Juktinama Korithile.
1500 per
There was an agreement also for taking rent. Where is the misappropriation? Where is the interestment? What kind of interestment is this?
109 Your Lordship there, Your Lordship.
109 means has they sold it?
That part, Your Lordship.
Then what is your case? Your own evidence. I am not reading anything else.
Only one, the president of the circle, who has stated that without prior raise, that urea is kept in different place. That is there.
Because there is no place in the
society.
Have you investigated in that direction? That the space was there or space was not there? Is it your case in the charge sheet that was enough space was there, still he is taken somewhere else? Show me one sentence anywhere.
That part I will verify whether in society there is a space.
Issue notice. I'll say the proceeding. This is unnecessary. Issue notice. Written will show so. Mr. Mahanti accept notice. In the meantime, the proceeding arising out of GR case number 369 of 2023 in state. Yes.
Problem.
28.
May it please your lordship. This petitioner faced a proceeding under NI Act. The judgment is at the concluding portion of the judgment. Your Lordship may kindly turn to page 27.
27.
27, 28.
Yes.
28 is the compensation amount. 14,68,000.
Yes.
He has already paid the amount to the complainant. The receipt is at place 32, 33.
You have been convicted and 14,68,000 is the
Compensation amount.
Yes.
That I have already paid to the complainant. Page 33.
After this order?
After this order.
Where is that?
Page 33.
This order is dated?
Order is dated 10.
14/11/2023.
Yes. Thereafter, on 30/11/23, I have paid the amount.
One day before?
No, subsequently. There is 14/11, it is 30/11.
30. Okay.
30.
Okay.
Subsequently,
Where is that receipt?
Receipt at page
Yes.
33.
নগদ রাশি
14,68,000.
Yes, নগদ রাশি.
Thereafter, I filed a petition because on the basis of my depositing a security money of 1 lakh and depositing my passport, I have been granted bail. I filed a petition that I have already paid the amount. My money may be refunded to me. The passport may be refunded to me. That has been rejected. Let notice go to the opposite party so that it can.
Has the trial court issued notice to the?
No. Trial court said since you have not filed appeal, I am not going to allow this.
Conviction stands.
Conviction stands. Let notice go to OP number 2, the opposite, so single opposite party with the complainant, so that it can be decided here.
Yes. Okay. Issue notice.
A particular date may kindly be fixed.
But the conviction stands, you have to file appeal. Why don't you file appeal?
Once I have paid, that can be decided here. That is why I have come here.
You can file an affidavit, appeal, and the appellate court can decide it.
Along with, my lord, again, I have to go for appeal. All these things can be done.
How can short circuit, even if I am satisfied, the appellate court has to exercise.
I have not filed any appeal because I have already paid. That is
what I'll do is, I'll tell you, I'll record everything and relegate it to the appellate court. You file an appellate court and move application.
Then your lordship.
148.
Yes, your lordship.
You have already complied 148.
Yes, your lordship may say that he will decide it within.
Yes, that is a better idea.
Yes.
Again, after everything,
my lord, I will not object to that.
Right. Petitioner was an accused in 1cc case number. What is that?
1cc case number 95 of 2012. Page 9.
Initiated by opposite party against the petitioner for alleged commission of offence under section 138 NI. The petitioner was subjected to trial. The JMFC 1 Cuttack while its judgment dated, where is the date? Judgment dated
14/11/23.
14/11/2023 has convicted the petitioner and for the offence under section 138 and sentence him to, what is the sentence order? Sentence the petitioner to, where is it?
Page 27.
Okay, offense. More than 10 years.
Page 27. In default to undergo.
Yes. Sentence the petitioner to pay compensation amount of rupees 14,68,000 and then default to undergo simple imprisonment for 1 year. 1 year. 1 year. After the judgment of conviction and sentence passed by JMFC Cuttack, JMC 1 Cuttack on 14/11/2023, the petitioner on
30/11
on 30th of
30th November
have made good the entire payment for 14 lakhs 30,000 to the opposite party. Towards the same, the opposite party has also issued a receipt which has been placed as annexes to the present petition. The when the petitioner was convicted, he had deposited rupees
1 lakh
and also submitted his passport to avail the bail. Since the petitioner, after the conviction order, has complied with the sentence, has already paid the compensation amount as awarded by the trial court. He moved an application before the judicial magistrate first class, inter stating that the compensation as awarded against him has already been paid. So therefore, he sought the release of rupees 1 lakh, which has been deposited before the court while availing the bail. The said application has been turned down by the impugn order dated 24/9/2024. Hence, the petitioner has approached this court against this order. The fact remains that the petitioner has already been convicted and sentenced by the court of JMFC Cuttack in 160 page number so. Therefore, the inevitable conclusion is he needs to file an appeal against the conviction. At the same time, it is borne on record that the compensation awarded against the petitioner by the trial court has already been paid. Be that as it may, the petitioner shall resort to the remedy of filing an appeal and move a fresh application before the appellate court in that regard. In the appellate court, inter making payment, making a prayer for the release of rupees 1 lakh, which has already been deposited, and the passport also. The release of 1 lakh and passport deposited before the court below while granting the bail. If the petitioner moves such application in the appeal, the same shall be considered within 15 days.
My lord, your lordship may say delay shall be condoned. Delay shall be condoned. Delay in filing the appeal.
Obviously, for section 14 benefit you will get because of this pendency.
You also may write that
15 days I have said so.
Your lordship may mention that, otherwise again that they may say that delay is there, that is the problem.
I don't know how many days delay, why. See,
14/11
2023.
23. Delay
when you have filed here?
On 24/3/25. Your lordship may say that, otherwise, my lord, delay shall be condoned.
And the petitioner is also at liberty to move an application for seeking condonation of delay in filing the appeal in view of the development which has unfolded in after the conviction order has been passed. If such application is made, it shall also be considered favorable. And the conviction order has to be set aside.
My lord.
And the appellate court can only do that.
If I would not have come to this court, then it would have taken another 4 years.
Yes.
29.
May I please? The impugn order is I have challenged the passing of the proceeding, my lord. Because 307 and 149 is not.
Yes.
But 307 and 149, the present petitioners have been implicated, and in the preliminary charge sheet, their name was not there. They have been shown as absconder, my lord, and subsequently 2 of the accused persons were released on bail on the same allegation.
may I pray, let them surrender on parity payment.
NBW has been issued.
No NBW has been issued.
Then 24. You have been shown as an absconder.
Yes. That is
How
one.
many accused are there?
4 accused persons, madam.
2 of them have been apprehended.
Yes.
They are
On bail.
All the petitioner.
Yes.
Petitions.
Twice.
They may appear. Parity is the petitioners have approached this court by filing the present petition seeking quashing of the court part PA's case number 258 of 2023 registered against them. Besides other 2 co-accused persons for alleged commission of offences punishable under section 147, 148, 294, 307, 149. Mr. Mishra, let us comment for the petitioner at the outset submits that he will be pressing the present petition. Rather, on instruction, he will submit for the court, appear surrender before the court on or before 30th of April 2025 and seek remedy available to them under law. He further submits that the 2 co-accused persons, those who have been apprehended, has already been enlarged on bail. However, the petitioners has been shown as an absconder in the charge sheet. It is open for the petitioner to move application for grant of bail after surrendering and surrendering. It is also open for the petitioner to take all the grounds as has been urged in this present petition, seeking grant of bail, including the ground of parity. Yes. Anticipatory bail application rejected.
My lord,
Twice, sir.
মানে সে দুইটা অর্ডর টিকে দেখেইবি সে দুইথর যাক ফাইল করছেন অরিজিনাল কোর্ট হওয়া কথা জেএমএফসি সে তাথরে লেখি দিয়েছেন সিটি কেস লেখিকি তাকে নিয়ে যাচ্ছেন সেশনস কোর্ট সেটি সরেন্ডর করিବାକୁ ডাইরেক্ট কেমতি হবে?
It is also brought to the notice of the court that twice the petitioners have twice unsuccessful in their attempt to get anticipatory bail.
Yes.
Anticipatory bail. This court also rejected.
Yes. দেখুন অর্ডারটা দেখুন।
This court by the order dated so and so in so and so have already rejected the anticipatory bail.
Surrender କରିକି
however granted liberty to the petitioner to surrender before the court below and seek remedy as per bail. And hence the prayer made by the petitioner to surrender and resort to the remedy within under law deserves merit in view of the observation made by the coding of this court in so and so. ठीक है?
The entire case, my lord, emerges from romantic relationship between the petitioner, in-law, married, blessed with child, male child, and now they have set up a family. My lord, the entire
marriage documents are there.
Yes. Enter resonates on the bedrock of your lordship's judgment in Rosalind case, followed by Fayazuddin, my lord. Entire case, my lord. I've also.
What kind of marriage is this?
My lord, temple, my photograph is there, my lord.
Where is that photograph?
Yes. May I invite your lordship's kind attention to my page, my lord, the photograph, marriage photograph. Page 17, my lord. May I invite your kind attention to page 17. Got married, my lord. And also, my lord, I have intimated them that your lordship permit me, they will come tomorrow, my lord. I will call them. They set up their family, my lord, and staying happily.
Who is the informant?
Pardon? Informant is the father.
Father is there.
Yeah, I met him party, but
father
also
informant is not made party. And informant is there, but the victim is not made party.
Both
are they blessed with the child? No.
The petitions are the husband and wife.
Yes.
Alleged husband and wife.
Alleged.
କଣ ବାହାଘରଟା କିଏ କହିବ?
Alleged.
issue notice. Issue notice.
Okay, well, opinion number
Married already. This is joint petition.
yes, joint petition. Opinion number 2 is further the informant.
Okay, issue
I'll
notice.
take notice.
Huh?
Let us short date document because your lordship judgment is covered.
What is the stage? The investigation is over.
No, investigation is not over
Only
because
363 now.
I only 363.
But my responsible lordship, initially affair was registered in 2020, your lordship. But the facts remain, the marriage was celebrated in 2000. That marriage, even assuming that marriage is correct, true and correct, that marriage was celebrated in 2024, your lordship. And at the time of initial registration of affair, the minor.
What you are doing then?
6 postcode, perhaps the charge sheet and file might have 6 postcode also. Charge sheet copy.
Might have no, but see, only the charge sheet is
Charge sheet copy is not.
FIR is filed. He says the charge sheet has not yet been filed. 2020 this thing, FIR.
Yes, sir.
And they are married in 2024.
24 major hela pare vivah rechi teno application hochi minor.
No, minus. At the age of 60.
You get instruction whether charge sheet is filed.
17 ବର୍ଷ ଯେତେବେଳେ ହେଇଥିଲା 17 ବର୍ଷ something
See, they filed the marriage proof and affidavit and everything. Yes.
So finally set up family only.
Leave it.
Let short date.
Short date.
Let no receive some protection of पिला छुआ धर की जाती तो.
No, see, 2020 nothing has happened. What will happen in 2025? You are already married. Nobody could touch you.
Because so blood I appeal because my learners class.
Nothing has happened since last 5 years. Now, after filing the petition, everything will happen.
I'm getting panic right now. Because
no, nothing will happen. Yes. If they would have arrested, they would have arrested by now. Yes.
Order of cognizance is impugned, Lord. Page 19, that is section 138 of NI Act.
Page 19, huh?
Again, that is only order of cognizance.
Yes.
Nothing is there, Lord. Your Lordship may kindly come to page 10.
10, huh?
Para 3.
Yes. Yes.
Date, place, and time of occurrence. Your Lordship got it?
Yes.
Check was issued on 30/11/2022. Sorry,
No.
Check was issued on 30/11/2022.
Yes.
And check was bounced on 2/11/2022.
Hey, you read it on 2/11/2022.
Again.
When the check number so and so was issued in favor of so and so.
Check was issued on 2/11, but bounced on 30/11/2022.
Automatically, when the check dated check number so and so.
30/11 check sign କରି ଦେଲା bounce କଲା 2/11. That is why I am before you.
No, the typing, see, the junior lawyers are filing it. Small typographical error.
It is not typographical error. Now,
show me. Come to the body. Come to the body.
Page 3. It can be typographical error. Page 3, Milord, page paragraph 3 of the petition.
Paragraph 3. Okay. Next.
Paragraph 4, Milord. A court taking cognizance cannot presume, Milord. He has to take cognizance on the material available. Now, Milord, kindly come to the last page.
1 minute.
Page 15. The documents is relying. That is also interesting.
Demand notice was
ସେଟା limitation ପଳେଇ ଆସିବ ଆଜ୍ଞା
1912.
ସେଠି ପୁଣି limitation ପଳେଇ ଆସିବ ମାସେ ବାହାରକୁ ହେଇଗଲାଣି
Let us see.
ବର୍ତ୍ତମାନ documents related କୁ ଦେଖନ୍ତୁ page 15
written memo 2/11
check ହଉଛି 30/11
there is a problem
2/11
there is a problem issue notice to opposite party number 2 written evidence also Mr. Das and counsel for the petitioner has taken me to the copy of a complaint. From the reading for the entire complaint, it reveals that check, the original check has been issued on 3/11/2022, whereas the original written memo appears to be on 2/11/2022, issued by the branch manager of SBI, Jagat Singh Road. Therefore, he submits that the entire case is a fabricated one. Issue notice, so and so, written will so and so. In the meantime, the proceeding will be for so and so state. Yes.
Hon'Ble.
May I please? Let him move application for adjournment. Application. Take on application. Please.
May I please? Well, in this case, the present petitioner is the husband and the informant is the wife, my lord. Before, with a prayer that the second FIR at Annexure 1 for quashing of that FIR and consequent proceedings, my lord. Before placing that.
Notice 498.
498, no coercive action. Otherwise, the petitioner is a government employee. Our marriage ro 12 वर्ष भितर किछि dispute नहीं. 12 वर्ष रे FIR देइछन first FIR second FIR टा. Second FIR husband नारे किछि नहीं, खाली just husband रो जमी गुडा के सब हमर नै जियो बोली कि other family सहित dispute बोली कि लेखुचंदी Annexure 2 रे. Annexure 3 तापरे FIR second FIR रे.
But in a 498 case, why have you not implemented the informant?
Sir, सेइत लगे अगर notice टा जाओ no coercive action.
काग notice दी. काग notice दी कौन है? काग दी notice. काग दी notice कौन तो?
Informant.
He is already there. For state.
Informant हम बोल लेते.
You have not done the, what can I do? It's a 498 case. This is a matrimonial dispute. You have bring the wife. We'll try. Land Council Party petitioner seeks leave of this court to implead the informant in the present case as the opposite party number 2. Let him do so within 2 days. Issue notice to the newly implemented opposite party. Mandate more parties to be filed. File it now.
No coercive action. Police arrest कर देला आउ compromise नहीं करेंगे.
Any application bail
application my lord.
No bail application which has been rejected.
No, सेटा consider करलेनी husband रो. Second.
Where is that?
My lord, that is the.
Where is said? Where is the order?
Yes, I have written my lord.
Where is that order?
In my. That is ABLPL number 2120.
Where is the order? Just show me the order.
My lord. फास्ट से बेल थिला 3500 भी दउची एटा आ गुटे सेकंड है.
But you have already burned your fingers. How can I do? How can I ignore this order? Very specifically, it is stated, taking into account the nature of allegation, this court is not inclined to entertain the ABPL in respect of petitioner number 1, Pradeep Kumar Patra. You have Pradeep Kumar Patra.
My lord.
Then one court says, I will not give, and I will pass no court.
No, my lord.
How can I do that? I can't do that.
My lord.
Undermine this order.
No,
you have burned your fingers. What to do?
That is not my lord, my intention. Your lordship may kindly glance to the annexures. Thereafter pass. No coercive action.
Am I sitting as an appeal over this order?
No.
Then?
Anticipatory bail is not time for renewal because all the materials.
See, what I'll do is, since I'm entertaining this petition, issuing notice and all, if you want, I will record your submission also. On the basis, you file another application and get it, get in another order. I can't, sabotage the order of a coordinate bench like this.
I may be liberty to that extent file the.
I can't sabotage an order of a coordinate bench. One bench says that no anticipatory bail, you file a 482 petition, I'll pass that and no coercive action. This is, this is not permissible. I can entertain this petition on its own merit.
Yes.
I can quash, that is a different story. I'll issue notice on the application also. Issue notice on the application for interim direction. What is that? Which is that application? Application? Application 906 of 2025. Issue notice on the application as well. Okay. 34. And who is arresting nowadays in 498? You tell me. Nobody is arresting.
Sir, if your honor will see the annexure 2 and annexure 1, the vindictive attitude. The present petitioner is a teacher, my lord.
Why have you not filed this annexure 1 and 2 before the anticipatory
So
bill?
that I will file, my lord. If that,
This would be a fresh ground for you.
Yes,
That
yes, my lord.
we should notice and
that has not been given with the knowledge of this honorable coordinate bench, because at that
so
time.
now you can say that change circumstances is 482 court is entertaining. Yes. Okay.
Okay. So I will add party, my lord.
Do it within 2 days. Huh?
Yes, yes.
34 for pausing of the proceeding, because the petitioners are the aspirants of army recruitment. Due to the agitation of about 1,000 persons after announcement of Hon'Ble and Agnipath.
Yes, where is that another matter, Agnivir? 2 days back I issued notice.
It has been fixed to
Agniveer
9.
wala matter.
It has been fixed to 9.
Uttila na Agniveer?
Yes, Lord. Mr. Biswal, my Ghanaian brother, Mr. Biswal, correct.
Issue notice and tag with that.
Yes, Lord.
Same Agniveer.
Another matter will be
1, 2, 3, 4. of-
Writing and all.
1, 2, 3, 4 of 25. That is, the number is 1, 2, 3, 4.
1, 2, 3, 4 कर दियो. Issue notice, tag with it. ताइने जहाँ order चाहिए कर दो. Same. I have passed some order there. Yes. 1, 2, 3, 4.
Fixed, so it may also.
Yes, yes, I know. See, not only in Orissa, throughout the country, this has happened.
going in Agnipath post
For that, you can prosecute the young people. Just see the age of these people.
21, 22.
21, 22, 24. After all, this, you can't do that. You seek instruction in both the matters.
Yes, yes, yes.
Yes.
Okay.
Item 59, my lord. That matter, my lord, a 490 case has been quashed by this honorable court, my lord.
Give me that.
Subsequently, one counter case has been filed by the mother-in-law against daughter-in-law and family members, my lord.
That is PSK.
My lordship, on 8/12/21, the petitioner was released on bail. Furthermore, due to unforeseeable circumstance, on 27/2, the petitioner could not attend the learned JMFC and NBW was issued against him.
27 to 25, huh? Okay.
27 to 25.
500, yes.
56. May I please your lordship, this is a Belgium matter. Petitioner.
My lordship, urgent certified copy.
Lordship.
27/9/2023. NBW bail.
Lordship, bail is 19/7/2022.
19/7/22. Okay. 500, yes. 500, yes.
37.
Pass over. The request of client counsel for the petitioner, adjourn. Yes.
38.
Non-AP is for the petitioner. In the interest of justice, adjourn. Yes.
39.
Are there in 39? Yes.
My lord, this CMP is directed against the order passed by the additional district judge in RFA 15/41 of 2015 in deferring the consideration of the petition filed by the petitioners, in which the petitioners prayed for a direction to the concerned authority for production of certain sale deeds that and to send those sale deeds for examination to the forensic expert, my lord, the handwriting expert, my lord. And that petition was filed on by order dated 29 March 2016, the Learned Additional District Judge observed that the hearing of the petition shall be postponed to the final hearing of the appeal, my lord. Against this order, we have approached this honorable court. My lord, the fact is that both the petitioners as well as the opposite parties claim a certain properties from the same vendor. The stand of the petitioners is that by RSD undated 2002, by two separate sale deeds, the vendor sold the properties to the petition number 1 in one sale deed and by another sold it to other petitioners. But the stand of the opposite party is that in 1988, a petition by Exhibit 2, which was
Here agreed by which order?
my lord, I have agreed by order dated 20 Annexer 6, my lord, page number 37.
Yes. What is wrong in this order?
My lord, my prayer is that it shall be heard first and thereafter.
What the court only says that your application will be heard when the appeal is heard, that's all.
Yes, my
What is wrong in it?
My lord, my dispose of in this slide, my lord, giving.
See, you move some application. Court says that yes, the application will be heard along with the appeal. That's all.
My lord.
What is wrong in it? I don't know.
My lord, my dispose of.
What will I dispose of?
My lord,
what should I say? You tell me.
My lord,
I'll say the same thing. What the court say?
My lord.
Petition.
I'm maybe pardon, my lord.
Yes.
I am the decree holder in title suit, original title.
What is this? Just see the order. What the order only he moves some application in the appeal. The court says that the application will be heard at the time of hearing.
Yes,
of
my
appeal.
lord.
What is wrong in it?
They are praying, my lord. That
Don't further.
yes,
Then do you want me to set aside or what?
No.
Then why are you unnecessarily arguing?
My lord.
Petitioner is agreed by the order dated 29/3/2016. I don't know why this matter is pending from 2016.
My lord, they are praying adducing new evidence.
Whatever you go and tell when the application is moved and decided, then you tell me.
My lord.
29/3/2026 passed by Learned additional district judge Bhubaneswar in RFA number 15/41 of 2015, whereby the application moved by the appellant petitioner to call for some certain documents has been adjourned to be heard along with the appeal. It appears from the impugn order that on 8/9/2000 on when you have filed the appeal. When the appeal was filed?
Well, on 6/5/2016.
On 6/5/2016, the present petitioners filed the RFA number so and so. Subsequent thereto, on 8/9/2015, they have moved an application for calling certain documents. The opposite parties have also filed objection to the application. The appellate court, while taking into consideration the application and the objection, passed the impugn order inter alia stating as under. It needs 37 ray pura heard. Paragraph. I find no legal infirmity in the matter, as the trial court has, as the appellate court has only deferred the hearing of the application to be heard along with the appeal. Hence, no adverse order. Since there is no adverse order passed against the appellant petitioner, I'm not inclined to entertain this petition. However, it is expected that the application moved by the petitioner shall be disposed of by the appellate court before the appeal is finally heard. Yes.
My lord, may grant liberty to approach this honorable court in case of any further cause.
My lord, one prayer, my lord. Indirectly, he is praying that additional evidence should be produced before the appellate court, which is not approved by the.
Argue those things before
that will be decided.
Appellate court has not formed any opinion. Appellate court only say that I'll hear the application at the time of appeal. If it is allowed, then it's a different story. You will come here. Yes, next.
My lord, oblige.
One. Item 40 is there.
नहीं 40 टा এটা প্রাইভেট পার্টিতে আর্গুমেন্ট
40.
সকালে কে আছেন করেন
One on behalf of Mr. Mishra, somebody asked.
আই এম মিশ্র মাই লর্ড
No, there are many Mishras here. There is
না
none.
কହୁছে না 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 সমাপ্তি কামিশ্র কହୁছে
No, somebody mentioned. I
না না সেটিকে
distinctly
না
remember.
না ସେ ଭୁଲ କରିଦେଇଛନ୍ତି your lordship take up କଣ ହେଇଛି ମୁଁ କହୁଛି my friend
Who has done it on your behalf?
ନାଇଁ ସେ ସମାପ୍ରକା ମିଶ୍ରଙ୍କ ବିହାରରେ ଭୁଲ ବୋଧେ କରିଦେଇଛନ୍ତି ଏଇଥିପାଇଁ explaining why
Hmm.
my friend Miss Samarthya Mishra was appearing in this case in the original second appeal, which is the order of which is sought to be reviewed in this review petition. Now, she has also given power, and my other associate also has given power. This review application has been filed, and I have been engaged. Maybe under the misconception that she has to conduct, possibly some adjournment might have been sought for. Man, more official के adjournment मांगना कि your lordship take up while assist and your lordship decide the fate whatever way your lordship pleases.
She has her name is appearing.
She there, she's with me. That may be some
Let us
kind
see.
of-
Let us see the Vokalatnama.
I will not appear in a case where there is a conflict.
I know, but let us see.
Be assured of
Let us see the Vokalatnama. Who's
ତାଙ୍କ
Vokalatnama?
ସେ ଆଗାମୀ ଡାକନ୍ତୁ ସେ ଯୋଉ ସାର୍ ଆସିଷ୍ଟ କରୁଛନ୍ତି ତାଙ୍କୁ କୋଉଠି ପଚାରିବି
No, see the Vokalatnama in the review petition also being filed by Samapika Mishra.
ଆଜ୍ଞା ଜୟ
Who
ପ୍ରଧାନ
else?
ସମାପ୍ୟା ମିଶ୍ର
Huh?
ଜୟ ପ୍ରଧାନ ସମାପ୍ୟା ମିଶ୍ର
J. Pradhan.
ସମାପ୍ୟା ମିଶ୍ର ଦି ଜଣର
J. Pradhan is also.
ଆଜ୍ଞା ସେ ତ କିଛି କଣ୍ଟ୍ରୋଭର୍ସି ନାହିଁ
No, somebody. Huh? Yes.
ସେଟା କେମିତି ଭୁଲ ହେଇଯାଇଛି କାରଣ I have taken her to confidence. I will never do that.
Okay, it's all right.
And your
Let us
I
see.
don't think-
Okay, then
like to
then
take a
J. Pradhan, who holds the Vokalatnama, has briefed you.
ଆଜ୍ଞା
Okay.
ଆଜ୍ଞା
Right. Yes.
ସେମିତି କିଛି କଣ୍ଟ୍ରୋଭର୍ସି ନା मैं I may be standing in a very tricky path in the sense application for condonation of delay in filing the second appeal has been rejected. Delay was 7 years, 7 months. 7 years, 7 months. That means this appellant, before the lordship and the review petitioner, is a tribal person. He had engaged a counsel for filing of appeal for district court. Now what happens? Now your lordship have been even pleased to observe in some matters relating to condemnation of delay that these tribal people usually they don't have knowledge of having meticulous following of the case, follow-up action of the case. What happened? He didn't
Rejection of your second appeal on the ground of delay.
delay.
Can a review lies?
Review will lie.
How?
If your lordship, your lordship was pleased to ask that question, but that is the next matter. The requirements of the provisions of review is to be satisfied.
No. You couldn't show the sufficient reason. Therefore, your application is rejected. Therefore, there is no adjudication in RF at all. And then you are seeking a review of an order passed in an IA, not in RFA.
Let me just explain then that again. Why review?
The dismissal of RFA is a consequential order because of the rejection of condonation. And there no review lies.
No, that's a
Where is the apparent error? You have to file a right.
If your lordship said there is no apparent error, I will not interpret different. But review will lie because it's a decree. The rejection of yes, madam. Because let me just clarify, doctor. I think that is 2004 Supreme Court.
And if you say that you are stretching too far, then it is more of a reason that you file a right proceeding before right court, not a review.
May I just humbly suppose the first appeal is dismissed on the ground of limitation not being condoned.
I don't go and join issue with you. I will take it as a degree. Even then your case is worst.
Madam, I'll just
now your case is become worse.
One more line with your lordship's kind permission. And in that event, an appeal will, second appeal will lie, a second appeal will lie before reasonable court, but it has been held by the Honorable Appellate Court and reasonable court that rejection of the petition for condonation of delay and the consequential dismissal of the appeal amounts to a decree and it is applicable. And that is how, madam,
you file a second appeal.
Merit your
file a second appeal.
No, second appeal.
You argued.
Second appeal was filed. Application for condonation of delay was filed. application for condonation of delay, that is why I said from the beginning, I stand on a very tough path. Application for condonation of delay has been dismissed. So consequently, my respectful submission would be, it's a decree in appeal, which is reviewable. My lord, your article, whether the review.
Reviewable if it is coming under the purview of Order 47.
Order 47?
Where is Order 47?
Read with section 114.
Don't bring
114 is the
But-
substantive provision. 47
That's
is
right.
procedural,
That's right. But
Procedural.
it has to come within that exceptions.
Honorable Vice Chairman, I have to finish about that. I may fail in satisfying your lordship on the merit of the review, but the review is maintainable. This is what I beg to submit.
Review against condonation of delay is not
My lord, it's a decree.
stretching too far.
May I just submit one thing? Because I will not assist your lordship for the sake of getting a relief in a matter. That will be even when I was not a senior counsel also,
Yes.
because it will not be fair to the honorable court also. Though definitely we will speak on behalf of our client, etc. On behalf of the engaging councilman, that's a different thing. But here, on merit, it may not warrant a review, my lord, but it's a reviewable decree. That is what I get to submit, my lord. Because she to delay condonation टाको appreciate करके कहले जे no delay is not condonable. And it may
There is no sufficient cause. Obviously,
sufficient cause हेलानी. Error apparent on the face of record मु जदियो आउ टिके ताको amplify कर देई छी review petition दे ये जो delay टाको. But error apparent on the face of record so far as the rejection of the condonation of delay petition is concerned, एते मु पाई पारनु. It may be to the displeasure of the council who has engaged me, but मुदाम कहूँ भी एते टिके होल. किंतु review is maintainable because this that so far as this rejection petition is concerned.
So then you want to say that I will entertain the review and thereafter on merit dismiss it. That's what you want.
Should I say that?
You have already
Is
said.
it not?
You have already said that.
Well, then, your lordship.
I don't think. I think you better remedy is somewhere else. Better remedy somewhere.
What more I
What should I do? Shall I give you liberty to approach the right forum?
Yes.
Better that you withdraw it, saying that I will approach the review is from office. I will say that review is not maintainable at this stage. You are withdrawing it to resort to the right remedy under law,
And
that will save you.
may I only humbly pray one more thing, your lordship, may kindly observe that with that liberty it is peaceful. So
Yes.
that will save me so far limitation.
Petitioner is the present review petition is filed against an order dated judgment dated 22/12/2023, whereby the second appeal filed by the petitioner has been turned down as because the second appeal was suffering delay of how many days?
Delay of 7 years, 7 days.
A delay of 7 years, 7 days. To sustain the.
I'm so sorry. 7 years, 7 months.
7 months. Along with the regular second appeal, number 397 of 2017, the petitioner had also moved an application under Section 5 of Limitation Act, being IA number 733 of 2017. The appellate court, while dealing with the application, arrived at a conclusion that the petitioner could not offer sufficient explanation, sufficient cause, could not offer sufficient cause to explain inordinate delay of 7 years, 7 months. Hence, the application was turned down. As a sequitur to that, the appeal, second appeal also has been turned down. Against the said order of the said judgment of the second appellate court, the present petition was filed. The prima facie, I am of the view that a review is not maintainable against an order rejecting application for condemnation delay to entertain the second appeal. However, Mr. Mishra, senior counsel, submits that the rejection of the second appeal being in decree, it is reviewable. I am not in agreement with the submission made by Mr. Mishra. At this stage, Mr. Mishra seeks to withdraw his review petition to resort to the right remedy available to him under law. The review petition is disposed of with the liberty to the petitioner to resort to a right remedy available to him under law. Okay. I have simply disposed up with the liberty to resort to right remedy available to.
That's all, ma'am.
Yes.
29 days, 7 years, 7 months,
29 days.
Then I'll be misunderstood not to have
Yes.
placed the fact correctly.
Then now you can utilize this and file the right.
So very much.
Yes.
So great.
I see. It is made clear that this court is not entering into the merits of the case insofar as the second appeal is concerned. Yes.
41. May I please file.
Yes.
The judgment passed in the second appeal is sought to be reviewed on the ground of being a nullity, and by the time the second appeal was heard, a right had accrued by in favor of the petitioner being the legal heir, in favor of the petitioner being the legal heir of the appellant, and they have not been heard in the matter. However, here, Your Lordship, when I was making mention of this matter, Your Lordship was pleased to pose me a question: what are the grounds on which the review can be made? Not only on the ground that I have not been able to produce certain documents despite due diligence, but also on account of some mistake or error apparent on the face of record, or for any other sufficient reason, review can be done. Now, what is that error apparent on the face of record so far as the judgment is concerned? I have to demonstrate. I have not been heard. Your Lordship will kindly bear that in mind. Now, if Your Lordship come to the judgment paragraph 2, the last two subparas, small subparas.
Yes.
That will be at page.
The appellant having died during the pendency of the first appeal.
Yes.
And his legal representative are come on record and are pursuing this second appeal.
These legal representatives of the review petitioners, they were never in the appeal, never substituted.
The representative came on record and are pursuing this second appeal.
That is not there. So that is an error apparent on the face of record. Because we have not been substituted. We never knew about the case. Then Your Lordship asked me when we knew, because recently when in the final legal proceeding we have been solved with someone because being the legal.
LRs are not brought on record at all.
No. So that is why I beg to submit
Mr. Mishra, and this review petition is filed against the judgment dated 25/7/2022 passed by this court in RSA number 323 of 2015. Mr. Mishra pointed out at the outset that apart from various other grounds urged in the review petition, the prominent ground on the basis of which the review is entertainable is that the appellant during the pendency of the first appeal had died, and the second appellate court records in subpara 2 agenda subpara 2 the subpara 2 he submits that the second appellate court has completely gone wrong on record, saying that the legal representative of the appellant already came in record and they are pursuing the second appeal. Indeed, there was no LRs brought on LRs of the appellant brought on record. This appears to be an apparent error on the face of record. The review petition is entertainable. Issue notice written to opposite party, it will be so and so.
I have paid for interim stay.
Yes.
For measurement.
In view of the aforementioned, in view of the fact that the appellant, second appellate court has completely gone wrong in proceeding with the matter on the assumption that the LRs of the appellants are pursuing the appeal, whereas the LRs have never brought on record. I'm of the conjecture, review petition deserves merit. Hence, the operation of the judgment.
Further proceeding of TS number.
Is it remanded or what?
No, it's a final decision.
Okay. The further proceeding in TS so and so.
TS final degree proceeding by TS number 115 of 2001, topic 116 of 2001, pending in the court of law and senior civil.
State further orders. Yes.
I'm so great.
Yes.
Topic 2, may I prefer article copy?
Yes. Yes, sir.
May I pray for one day time, my lord? Monday I will be filing my additional affidavit.
Additional affidavit for what, sir?
Regarding delay, my lords. Explaining delay.
Okay. Then the counsel for the petitioner seeks a week's time to file additional affidavit to explain the delay in filing the CM application. CMP. Take it. Granted. Yes. 42. Yes. Yes.
43, for if I may please your lordship, my lord. My lord, if I may. My lord, let me start my arguments. My learned senior can join in. Your lordship will recollect this is that matter wherein the orders of this honorable court has been sought to be recalled by the wife and the informant victim. The 498A and the other cases were quashed by this honorable court, wherein the wife was not noticed, and the husband, although there was a notice, the father, although the informant was noticed, but there was no appearance. Your lordship will just see 8/5/2023's order. 8/5/2023.
Yes.
Well, this is the order that we're seeking to recall. The service report states that valid service was effected upon opposite party number 2.
Where, which paragraph here?
But the first paragraph.
Yes. Service report.
Yes.
States that the valid service was effected upon opposite party number 2.
My lord, opposite party number 2 is
not represented today.
Yes, opposite party number 2 is the informant father, your lordship, my father, and that my learned friend is there. My lord, there was a death in the family because of which they have filed an application for recall. That is also there before your lordship's board. I, as the victim, who's the wife, has also filed an application for recall. So your lordship has to decide that whether this recall can be at my instance or at the instance of my father. So both applications are there before your lordship. We are on merits of the case, my lord, according to this.
On merits.
Yes, on merits, my lord, they state that Prem Kumar versus State of Kerala has decided the issue that when no part of the cause of action has taken place in Odisha and every action took place at Kolkata, then whether the matrimonial home that is there at Odisha, can the courts here have jurisdiction and whether an FIR can be registered here. My lord, the issue is no longer res integra, it has been decided, so Prem Kumar's judgment is not correct law.
Any part of the offense has taken place.
My lord, I'll just explain.
The wife shipped to the parents' house, then cause of action, part of cause of action.
My lord, the Honorable Apex Court says no. Cruelty is a continuing cause of action. The issue was whether any part, after she leaves a matrimonial house and comes to her parental house, whether she can institute proceedings there. The Honorable Apex Court has decided the larger bench decision.
That's what I am also saying.
Yes. So once I'm at my parental house, I can institute.
Cause of action continues.
Yes, but this honorable court, by relying on Prem Kumar, has given a wrong decision, my lord.
Yes,
Cannot happen.
Yes. Number 2. You are also joining.
Yes. We are joining.
Yes, madam.
Arguing in order.
See, this order has to go. It has to be heard on merits. Because this is, first of all, he says that he has not been heard. Second is Prem Kumar in state of Kerala, that is 2008 judgment is relied upon. Whereas the subsequent judgment says that the cause of action continues. Imagine if the daughter-in-law is in the girl is in the in-laws house. She has been tortured. She was thrown out. Where she will go? She will go to her parents' house. And this cause of action continues. From parents' house, she can file a case. 498A, whatever. Every third day this is being happening here. Then a place where she was tortured by the husband, she has to go there. She has to go there and file the case there. That's not possible. Suppose you are married and gone somewhere else. So this is what the problem is. I'll set aside it and lease it for hearing. Password, see.
I'll wait your lordship.
I'll set aside and let us hear on merits, that's all. Yes. Password, I don't know. I don't know.
But if we can take it at 4 p.m, if my learned senior
I
permits.
don't know. Let us hear. Otherwise, a short date will be given. Yes.
44th, may I please?
Let order under annexure 4C order dated before that I am drawing your lordship's attention to the person to whom I had engaged as to look after my transport business, that means vehicle. He has tampered the engine number, chassis number, changed the number, and against whom I had filed lodged the FIR, and they both have them have been charge sheeted. And the MVI was on the direction of the London magistrate. MVI also submitted the report that vehicle was seized and was taken into the judicial custody. There, the MVI inspected the vehicle, and the report, you'll also may see the page.
Wow.
Page 49.
What is your grievance?
Still, MVI stated that the vehicle which has been seized, the number plate, chassis number, and engine number is not the genuine, as it was generally embossed by the manufacturer.
Yes.
And both the opposite party number 5 has been charge sheeted. Still, on the application of opposite party number 5, the London magistrate had released the vehicle under section 457, and my petition seeking release under section 457 has been rejected. That is my and I am the real.
Where is your rejection?
I have been deprived of. I have been paying the loan, and he is enjoying that vehicle. He is enjoying that vehicle.
I am appealing for the opportunity 5, my lord.
You are the accused.
My lord, I am.
You have manipulated everything.
No, my lord.
That's not the case.
No. My lord, on basis of FIR, police seized the vehicle from.
Are you claiming to be the owner?
My lord, he did not. He failed to establish that the vehicle which was seized from me is belongs to him.
Because the number and everything you have changed. What to do?
No, my lord. That he did not establish.
That's the report is.
Your lords, we kindly have that to the.
And the MBI also opined that your lordship.
How are you claiming you are ownership? You tell me.
Yes, my lord.
Show me. You are ownership paper.
My lord, the vehicle.
Forget about him. I'm not entertaining his application. You establish your case. How are you entitled to the?
My lord, the vehicle which was seized belongs to some Liaquat Ali, my lord. He sold me, my lord. That is the page 44, my lord. 44 and 44 and 45, 46 and 47, my lord.
46 and 47, yes.
47, your lordship, Liaquat Ali, that I have sold my tractor truck bearing registration number 0R04.
Yes. This is the number.
This is the number.
Which he says has
He
been
said
manipulated.
that is the different vehicle.
That vehicle was seized.
Okay.
And
Issue notice, you have to answer.
notice
You have to
was
answer
issued,
it.
notice was issued,
Huh.
notice is was issued, the OP number 5 has already entered.
He has to answer it now.
And
Yes, Your Honor.
Whose vehicle is this?
Also, the case there is not with me also. Let it go next week also. I'll file the accept on the whether the vehicle number has been changed or
Change or if it is changed,
or this is
then
not changed.
yeah.
Whatever.
Whose vehicle is this?
Yes,
He is the owner or he is the owner?
right owner.
The rightful owner has to be given.
Right to owner can be established as per the suggestion made by the MBA that the vehicle may be may be inspected by the expert of manufacturer. Means unless and until that vehicle is produced before the police, how can the expert of manufacturer?
Then we will comply that order.
That has not been complied, but that has not been directed. Law and Magistrate.
Okay.
The vehicle is directed to maybe directed to produce before the police station, so that the vehicle can be inspected by the expert of the manufacturer.
Where is that order?
Yes, the order at page 49, report of 49, and a release order at answer for 4-3.
One more thing, Your Lordship, there is noting in that place requisites for instance of noting OP4.
There is a
OP4 who has been arraigned.
You comply with the.
Comply, Your Lordship.
No.
Not traceable. OP4 is not traceable.
RTO order dated 16/7/2013.
Yes, Your Honor.
It says that it has to be verified from the manufacturer. Have you done it?
No, that has not been
verify
done.
that.
Yes,
Kind
Your
of.
Honor.
The petition is arising out of an order passed by the court below while disposing of the application under section 457 CRPC in CRLMC number 15 of 2014, whereby the application moved by opposite party number 5 for release for the vehicle. What is that vehicle is? Vehicle. What is that vehicle name? Vehicle.
Is truck. Registration number OR04D3.
No, don't tell me the number. Vehicle. What vehicle is this?
Truck, Your Lordship.
Truck, TML truck, 6-wheeler truck.
6-wheeler truck has been released in favor of the opposite party number 2.
Number 5.
Number 5. Where and the application, similar application moved by the petitioner under section 457 CRPC has been rejected.
Rejected, and this application has been allowed or released.
Counsel for the petitioner has pointed out the annexure 5 to the petition, whereby the RTO filed its letter dated report dated 16/7/2013 as opined that the original chassis number and engine number can only be ascertained from the manufacturers.
Experts
manufacturer.
by their mechanism.
Mr. Mohanty appeal for the state submits that you would seek instruction as to whether the report dated inquiry expert opinion as per the RTO suggestion dated 16/7/2013 has been taken or not. Lease the matter also. Yes.
45.
Lordship, please say.
Yes.
Lordships have posted today the matter for consideration of my interim application.
Mm-hmm.
Consideration of my interim application was the Lordship said there were other petitioners also. This is arising out of the order of the Lokayukt. It's the operation of the order of Lokayukt was stayed. Despite of that, the learned court below had taken cognizance and summons were issued. Last occasion, I had served the copy, minutes. On vigilance.
Vigilance.
Date copy or date. Let's see what. आपको भी देखते हैं, कोई देख. बटन आप कर
Lokayukt, huh?
Well,
yes. Came out.
Yes, sir.
Called tomorrow matter, sir. Maharana is dealing with the CRMC matter.
No, Lokai passed some order on the
Right.
basis of which EOW case is registered.
Right.
That order was subject matter of challenge in a writ petition, that
Yes.
is 152 of 2024. That has been set aside. So therefore, a notice was issued and interim order was passed. And tag with that
Maybe
issue notice and tag with this.
Yes.
Tag with the.
Let's one submission, Mellis, may I make? Since the interim order which your lordships had passed in that previous day, so they had to move application there and the matter was supposed to be stayed. So Mellis, now the so far other petitioners are concerned, Mellis, their file is stayed, Mellis, but so far I am concerned, Mellis, they are proceeding with the matter. So Mellis, I pray, Mellis, this order may be passed. Same order may be passed.
Tag with that. Yes. The interim order. In view of the interim order. In view of the interim order already passed in so and so, in the light of interim order, passed so and so, in the present petition also the same interim order. Yes.
Be clear.
Yes.
46. Let prepare extension of time to surrender.
What happened? Extension of time granted till 30th April. No further extension shall be granted. Yes.
Obliged. 47.
Either for the reason stated in the application. Yes.
On 47, I am appearing for the complainant, my lord. Earlier also I had prayed to appear. As because the matter was disposed of and the order reflected that it has been disposed of, so I couldn't file my vakulatnama. Thereafter, they have filed a application for modification that has been modified, and they have also granted further more time to surrender there. But my appearance may kindly be noted here so that I can file my vakulatnama, and there are some specific facts which have been kept in that.
What is the final order?
Final order was, though it was disposed of by that time,
18 to 2025.
ମୁଁ appear କରିଥିଲି ସେଥିରେ actually dispose of ହେଇଯାଇଥିଲା finally, ସେଥିପାଇଁ ମୁଁ vakulatnamaଟା file କରିପାରି ନଥିଲି। ତାପରେ ଆଜ୍ଞା
dispose of, yes.
ତାପରେ 5/3 ରେ ସେମାନେ ଗୋଟେ ଫାଇଲ କରି ସେଟା modify କରିକି extension ବି ନେଇଥିଲେ। ତାପରେ
main matter is pending.
No, main matter is disposed of. Pursuant to that order on 18/2/2025, the main matter is already disposed of. I am a complainant. I am the complainant in the court below. I have not been arraigned as an opposite party in this case, though the matter relates to a POCSO Act.
Okay. They gave impression as if it is 138.
And surprisingly, my lord, the petitioner number 1 is a government servant. He has filed it affidavit here that he is a businessman.
File counter, whatever. Let counsel for the opposite party.
And
1 week time to file counter. File counter.
Complainant. Yes.
File counter affidavit.
My vakulatnama may kindly be accepted.
Yes, file. So and so enter appearance for opposite party.
138 भूल नहीं लिखा है।
Opposite party is not there, not implicated.
Yes, that's why they have not implicated me. In the main case, they have not implicated.
Also, then where is the question of?
That's why I sought permission of this court, though I am the complainant in the court below. And it's a 376 POCSO Act, my lord. NBW was already issued.
NBW is only filed this.
They have filed several applications for anticipatory bail, which were dismissed. Thereafter, they have come up with this 482 application, my lord. And getting a lenient view that the NBW order is set aside and to surrender. They have never surrendered.
See, you are unnecessarily creating confusion here. NBW was issued.
Yes.
Him. He came here.
Yes.
I set aside and I asked him to go and appear before the court.
Yes.
So to the remedy under law.
Yes, yes.
That's the end of the matter.
Yes.
There was some typographical error. Subsequently
Yes,
moved the
yes.
application. I corrected.
Yes, yes.
That's a mistake in my office.
Yes.
Okay, no problem.
Yes, yes.
What remains now? Whatever you want to do, go and do it there.
Yes, but
this matter is already disposed of.
Yes, that's why. I have got permission from this court that this matter is adjourned and I will file my
Just see the orders. I thought you were saying something else.
18/2 ରେ order ରେ ଥିଲା ଆଜ୍ଞା।
18/2 order ରେ I have already disposed of the
Yes, yes. ତାର 5/3 ରେ
there
modify ହେଇଯାଇଛି।
in place of the cognizance order under section so and so 138 is written.
Yes.
That has been corrected now.
Yes.
Then
And the order was also extended in that order also.
then he will go and appear there, right?
My lord.
Petitioner has approached this court by filing approached this court seeking the
My lord, they have misled this court by saying fake affidavit, false affidavit. He is a government servant. He has filed his affidavit that he is a businessman.
Where is 1cc case? Why have you written 1cc case? I don't understand. You come to your prayer in the main petition. Come to the prayer. Main petition. Come to the prayer. Yes. Read it.
Read it.
Can you read it? And the front page also.
Petition therefore prays that your lordship may be graciously pleased to admit this application and call for the recursion. After hearing the parties, this honorable court may kindly be pleased to pass public safety aside the order of cognizance directed edition of the evidence of this. Passed in 1cc case.
What is passed in 1cc case? 1 of 2024. Where is that passed 1cc case? Show me.
By the honorable president.
Where is that 1cc case? Show me.
Well, I'll keep it for passover. I call my senior.
What passover you appears to be I think you have misled.
No, my lord. I will
Misled this court.
Page 12, your lordship.
You gave an impression as if it is a case of 138. That's the reason the order was passed like that. Release is on Tuesday. Tuesday.
Yes, madam. It will be clear.
Clarify this what
Yes, ma'am.
exactly.
Yes, ma'am.
Yes.
My appearance
File it,
recorded.
file it.
No, madam. Okay, all right.
Appearance,
Yes,
file it.
all right.
48. What passover is 4 o'clock? Urgent. 49.
May I please, my lord. On the basis of compromise, my lord, both the parties have filed two applications for questioning of the proceedings initiated at the instance of either party, my lord.
What are the allegations?
Allegations, my lord, 307 is there. And they have annexed 2 is the agreement within the there is a amicable settlement by the
Amicable settlement is all right, but
Yes.
what are the offences? What is the stage of investigation? What is the
investigation charge sheet has been
where is
filed.
the charge sheet?
Charge sheet I have not filed, but charge sheet has been filed.
What are the allegations there in charge sheet? How many accused are there?
Accused persons, my lord, in one case, my lord, in first case, all the
In one case, petitioner is 20, in another case, petitioner is 60. Both vice versa.
vice versa, or political rivalry, my lord. At the intervention of the local MLA, my lord, he has been settled.
Already issued notice, you just check it up.
My lordship, the injuries are grievous, my
Yes,
lordship.
I know, see,
Yes.
very, very serious.
Yes, my lord. But last occasion, it was directed for filing of the affidavit by the injured persons.
My lordship.
Accordingly, affidavit has been filed also.
State has to assist.
Yes, my lordship. Another
It's
thing,
not
my
a very
lordship.
simple case.
My lordship, kindly have a gloss to the first case.
What not? All IPC offense you have committed.
Yes.
Yes. And my
All
lordship,
IPC.
he has 3
Because
antecedents also.
now, because now, my lord,
Yes, my lordship.
In first case, you are talking about?
My lordship, CRLNC 4885 of 2020.
because of village rivalry and political, my lord. During
That
last
doesn't mean that you
And
keep
all our 307 is there.
murderous attack by you.
one side there,
Then
Yes,
both of them will face.
one side.
See the kind of
Yes, my lord.
offenses you have committed.
Because of the development, my lord. Now we at the
Because it's not reason of the fight is not more important.
Yes, my lord.
The incident is important.
Incident
Reason may be
important,
whatever.
right? Because during the last Gram Panchayat election, my lord, it was happened, and subsequently, my lord, during the after 1 year, my lord, the next case.
And
has
he
been-
has 3 cases.
Yes, my
The
lordship.
first petitioner has 3 cases.
Yes.
What about the others?
Other than.
And all the cases are 370, 307, 323 to.
That village, my lord, was going on since 15 years, my
You
lord.
are a very good person. Yes.
In last.
What about the second one?
Second one is.
Same, my lord.
Palina?
In this case, my lordship, the Purnika Delusu, he has no antecedent, but
Purnikarna
she's
Delusu.
also an accident and previous, and the injuries are also
What about in the second case?
in the second case, my lordship.
All the cases are cases and counter cases, my lord. Within 2 groups, up 1 case, my lord. Both the persons are both.
Get
Yes.
yes. Not so simple. Yes. File reply, huh? File reply, yes. The State Council to file reply in both the cases.
Your lordship, and those affidavits filed by the injured persons, sir.
Give a copy. He'll
Yes, I
verify.
will supply the already
Yes,
copy has been
50,
submitted.
50, yes.
Your lordship may take note of those.
Yes.
Yes. There is no need of, there is a indication that notice has not been issued to the injured persons because they have already entered appearance.
It's all right. Give the copy to her and so
Copy already.
she can verify the.
Yes, I have already solved the copy.
Yes.
Item 50.
Non-appeals for the petitioner.
My lord, item 50, my lord. Item 50.
Yes.
My lord, we have already deposited requisites, my lord. But in your lordship's order, it was mentioned that requisites for 1 to 3. My lord, there is no.
1 minute. 1 minute.
Order was issue notice to oppose 1 to 3. There are 2 opposite. That's why the
Two respondent. Oh, no, 1, 2, 3 is there. This is. No. Okay. 2 respondent. And the order was 1, 2, 3. On the order date 12/2/2023, this court has directed to issue notice to opposite party number 1, 2, 3. The registry has pointed out the defect that there is only 2 respondents. Therefore, the notice could not be issued. Let notice be issued to opposite party number 2 and 3. 2 and 3. Yes.
My lord, opinion number 2 is minor girl said, my lord.
It's all right. 2 and 3. Yes.
In this case, my lord, the petitioner has filed the case for quashing of the FIR, my lord. So far, that the allegation against the petitioner is concerned, my lord. There is no nexus with that case, my lord, and moreover, he neither directly or indirectly involved in that matter. He is stated in that FIR. There, they have found one NGO, the accused person, and his wife, along with other persons, they have found an NGO and they have taken money from the informant, the opposite party number 2. But in fact, the petitioner name has not been reflected in the FIR, but his telephone numbers are reflected. That's why I filed the case before my lord's mirror.
Investigation is going on.
Investigation is going on.
Let it be concluded. Why have you come at this stage? There are some allegations against you. Investigation is going on. The offences are 294, 420, 468, 471.
Well, so far FIR is concerned, Miller. In FIR, the accused, the.
Got the bail.
No, I'm not in bail. I'm not in bail.
Your bail application is rejected?
No, I filed the bail application. But the Hon'Ble Court, this Hon'Ble Court has permitted me, if there is any appearance of arrest, then you will file bring the liberty.
Therefore, why have you come at this stage?
And
you are not even accused today.
My telephone numbers are there, Miller. And they will track that telephone number. They may take anything, course action against me, Miller.
Merely because your telephone numbers are reflecting in the FIR, so you came for watching.
Since the telephone numbers are there, the police is and take any action.
The police, what the police will do?
And I am the service holder.
Shall I remove your telephone number?
No, my
Then
lord.
what can I do? You tell me.
My lord, in fact, the investigation IO may kindly director to produce the documents. So far, my case is concerned, my lord.
I can't do that. I can't direct anything to the investigating officer. That's his prerogative. You are only in the FIR, your telephone numbers are there.
My lord.
The informant is given your telephone number.
My lord.
That doesn't mean that I'll quash it merely because your telephone numbers are there.
My lord, the police.
Let it be investigated. At this stage, how can I interfere? How can I interfere? You may have any apprehension, whatever. That is the reason when you apply for bail, the court says that you are not even an accused. Why are you come? Hey, you are inviting all this problem for yourself by moving this. You are not even an accused today. Why have you moved this? Withdraw it and right stage you come. Then counsel for the petitioner seeks to withdraw the petition or reserving his right to approach this court if cause of action arose at any stage. That's if charge sheet is filed, then you use this word order. Okay. Yes.
Obliged.
To that the petitioner is in custody, my lord, praying for early disposal of the case. Page 17, kindly see, my lord.
When the FIR was filed?
Order dated 7/4/22.
2012.
My lordship, kindly have a glance to page number 18.
18?
Yes, my lordship.
Yes.
Accused person, namely
Warrant
Mahapatra, Prakash Pradhan, Jitendra Kumar Jaina, Manoj Kumar Pradhan are present. NBWA issued against the accused Session Naik, who is the present petitioner, my lord.
My lord, he is in custody now.
Who are you?
He is in custody now.
Other you have been absconding and NVWR issue. Now you are asking for.
And it is.
4 months.
It is because of you. It is
I am
delayed.
not praying for bail, man.
It is because of you. It is delayed.
Yes, my lordship.
But
How
now
can you ask for expedition?
Now it is 4 months, my lord.
Maybe
And since 22.
because you are in custody today, you are seeking, but the delay is attributable to you only.
I have not filed any bail application in any court.
That's your problem. That's your problem. Right on. That's your problem. You have been absconding. Right on. Petitioner.
In similar
What are
effect,
you
so
seeking?
your lordship has passed a similar order. My lordship, kindly have a glance to this order. Another accused person.
When the statement under 313 was to be recorded,
Yes.
that time you escaped. You didn't come.
That's why, my lord.
And now you are there in the custody. Now you say that.
Now I have no scope for absconding, my lord.
Maybe because you have delayed it.
Same FIR, my lordship, another person has also filed the application for speed of the trial, and your lordship has passed this order.
What is this order?
Same order, my lordship, another person was filed because there
Another may be
are
filed.
5 or 6 accused person. One accused person also filed for speed of the trial, and he also like.
Same FIR.
Yes, my lordship.
Might, my lord. I don't have that knowledge, my lord.
Yeah, some Jitendra Kumar. And 302 is there, my lordship.
Yes. Case of the year 2012.
Then is there any stay?
No, my lordship.
Yes, there is a stay. That's what this order says.
Yes, but more.
There is a stay.
Copy, my lordship. Which will not-
No, this order says that the
Yes.
coordinated bench of this court by the order dated 6/9/2024 has stayed the further proceeding in ST case number 138 capital A of 2012.
That is not
pending the
split
court
up case.
petitioners.
Split up
Therefore-
because
A means it is splitted.
No, this is, I will not enter. You, half the thing you say, half the thing you concede.
No, I don't know, my lord.
Where
That
have you
order
said,
I don't.
where have you referred this, all this thing?
I have not filed that.
No. Petitioner is agreed by
Since
what
I am arrested and
Maybe.
languishing in custody since last
Maybe.
4 months, thereafter I play for without filing any bail application. I have preferred this.
Has filed the present petition exploring the following relief. Parallel. It appears that the petition from the reading of the proceeding, please before this court as annexure 1. it reveals that the petitioners have been absconded. Eventually on 17/1/2024, the following order was passed. Page 18. 17/1/2024, the following order was passed. Page 18. The counsel for the petition submits that the persons to the aforementioned order dated 17/1/2024, the petitioners have been taken into custody. The petitioners are in custody as of today. Therefore, they seek the intervention of this court for expeditious disposal of the trial. I'm not inclined to entertain this petition because at the instance of the petitioner, the delay in trial proceedings has caused, and moreover, at the stage of recording of the statement under section 313 CRPC, the petitioners have granted leading to issuance of NBW. Again, then, hence, no interference is called for according to the petition is dismissed. Yes. Yes.
Your Lordship, please to issue notice. It's a matter 130 application. My application for examination of D1 has been rejected. That's why your Lordship put up the small date and directed to take the notice. I have already issued the notice and the service perhaps.
Transit.
Pardon?
Transit.
This small date.
Service on the opposite party number 2, opposite party is not affected as yet. Awaiting service, lease the matter. Yes.
Lord, another answer, my Lord. My item 43, my Lord and friend is there. The Lordship has filed an application to recall the order. And on the guise that he has not appeared on the date fixed.
No. On the guise that he has not appeared, one thing.
Yes.
Second is the judgment
has been overruled
by the court bench. That judgment doesn't hold the field now.
Yes, I am submitting, my Lord. Your Lordship can see 362 of the CRPC.
Yeah, but
so far this
password. Okay.
T62 is concerned, my Lord. If an order has been filed or any judgment has been passed in a criminal case, that cannot be altered or to recall. In that regard, your Lordship has also well known that judgment of the 2001 Criminal Law Journal, Hari Singh Man versus Harbhajan Singh, where the Honorable Supreme Court has said in
technically you are correct, but this order is not
sustainable. So far the judgment, Prem Kumar, the judgment has been relied upon. Your Lordship can see that judgment for the moment, Prem Kumar judgment.
Prem Kumar doesn't hold the field. Prem Kumar doesn't, but the other argument which you are saying that wrong or right there is an order.
Yes.
So therefore modification is not
alteration
and
modification. I have
right
two judgments.
Challenge that order if it is wrong. That's what you are saying.
Yes. If he is there, then he could have approached the Honorable Supreme Court.
There you are right.
One thing. So far, Prem Kumar
in the guise of modification, I can't alter the substantive order.
And what
in a criminal case of 480.
May I answer, your Lordship?
Let me complete, sir. My friend has
judgment.
Two judgments I have.
Why don't you challenge?
I have already filed.
I'll just answer. I'll just answer.
You have 2 points. One is principle of natural justice. Second, Prem Kumar doesn't hold the field.
Yes.
Both the are substantive grounds. You can file an appeal and get it.
And your Lordship has in a writ application also, if it is disposed of, to recalling the order in toto, and when the writ application that court is functions officio, that cannot be recalled in toto.
Yes.
Here,
which paragraph you are saying?
My Lord, that is first paragraph 362. I have not the. I have in my copy. I have filed the earlier ones also in the file itself. Perhaps.
No. Which judgment? The judgment, which paragraph?
Yes, ma'am.
Yes.
2001 Criminal Law Journal, Supreme Court, 128 page, my Lord.
Para.
Yes. Paragraph 9, 9 and 10, your Lordship. There is no provision in Code of Criminal Procedure authorizing the High Court to review the judgment passed earlier in exercise the appellate or revisional or original criminal jurisdiction. Such a power cannot be exercised with an aid or order clause of section 482 of Code. This court in this case of
Yes,
state
how
of
do you,
Odisha
how do you
order-
answer to this?
The Apex Court has categorically distinguished 362 so far as vis-a-vis the power 482. Paragraph 10, your lordship may kindly have.
and subsequent judgment of the 2014 Milord in Kusabhai Ratanlal Rohit's
Please have
case.
paragraph 10.
Where is your application? Modification application?
My application. Lord, IA 2064. The Honorable Apex Court has categorically distinguished with recalling and what is modification. When we are seeking a recall, it is not modification and will not come under 362 and it will not be a bar. Moreover, this Honorable Court, in the case of Sibo Sankar,
No, see what is modification?
yes, in this is not
Modification is a typographical error or a
Yes.
substantive order relying upon a particular judgment, saying that this judgment is applicable. And you bring another judgment saying that no, this was not applicable. In fact, this is applicable.
Your Lordship,
Then
with the
this is
utmost of
not a
respect.
modification.
No, my Lord, I am seeking a recall. My Lord would kindly appreciate. My Lord,
A recall because the coordinate bench has applied the wrong law, wrong
My Lord,
judgment.
my Lord,
That
principles
can't
of
be.
natural justice as well as the error apparent on the face of the records. My Lord, this is what this judgment says. The 2021 judgment that I have just given to you.
Show me where
My Lord,
which
paragraph
paragraph?
10, my Lord would kindly
Which
have.
paragraph?
Paragraph 10, my Lord. Whether
10.
whether 482 powers are curtailed when there is a 362 bar. This is the answer that was there before the Honorable Apex Court, and the Honorable Apex Court answers an affirmative saying that 482 is a power which will have supersedence over 362. My Lord would please have that. Paragraph 10, then the quotations of Davinder Pal Singh, paragraph 46, and then paragraph 11 categorically stating so. Therefore, the respondent cannot take umbrage under section 362 CRPC because that the order has become final.
Reported age 2021.
2021 14 SCC 683. Correct question. 14 SCC 683.
Yes.
And then your lordship will see at paragraph 11 where the Honorable Apex Court says that therefore the respondent cannot take umbrage under section 362. The fourth line.
Yes.
So therefore, my lord, 482 powers are very clear. And this is an application under 482 which they had filed. And this is a case, and similarly, my lord, this Honorable Court in the coordinate bench has held that recall is different from that of modification. So 362 will not apply. My lord, please have the first paragraph. What is the question that is there before the single coordinate bench of this Honorable Court?
What was the order impugned there in 482?
My Lord, 482, my Lord, then I have a right to submit, my Lord. I am
My Lord, in this
challenging
case-
the order of cognizance.
My lord is asking in this case.
Jurisdiction only. Because your lordship may kindly see the affair.
No, jurisdiction ground is no more a ground.
Yes, indeed, your lordship.
Yes.
No more a ground.
Therefore,
now the only thing is now you have to satisfy me if a substantive order is passed.
Yes.
Saying that court has jurisdiction by relying upon a particular judgment. Under the guise of modification, can it be reviewed?
Yes, my lord, but kindly, this is not an application for modification. Your lordship will please have paragraph 10 again of this Honorable Court's judgment. Sibo Sankar, which I have given to your lordship, please.
Yes.
My
Let
lord,
us
best of
come
all-
to your application. Let us come to your application.
My lord, my application of IA 2064.
Yes.
Yes, your lordship.
Let us come. What are you seeking?
My lord, my grounds are that I have not been noticed and principles of violation of natural justice. And that is what the Honorable Apex Court says.
That's the ground in appeal also.
No, my lord, why I say so, my lord, because 362, whether that bar is absolute or not before your lordship. My lord, that question has been answered in negative, my lord, by this Honorable Court of Coordinate bench has already answered the same.
Here, please.
Yes.
Yes.
Whether the bar under 362 is absolute or not is the question that is falling for consideration before your lordship as of now. My lord, may I kindly see 362? Save as otherwise provided by this court or by any other law for the time being in force, no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical order.
Yes.
Error.
That my lord
Yes.
has also said.
Yes. Now, my lord, the answer is whether this is absolute or not. My lord, my respectful submission, it is not absolute. My lord, I've given two judgments. The first one that I gave to your lordship of the Honorable Apex Court, and the second judgment, your lordship may kindly see Sibo Sankar, in which this issue has already been decided by a coordinate bench.
Show me that order.
Yes, my lord, please have Sibo Sankar judgment that I showed to your lordship.
Where is that?
Sibo Sankar.
Yes.
My lord, this is a coordinate bench's order. My lord, please have page 3, my lord. Paragraph 12, 11 onwards, my lord. Paragraph 11. There can hardly be any dispute as regards the statutory prohibition referred above. But then the question is whether such prohibition is absolute. Further, how does such prohibition operate vis-a-vis the inherent powers of the High Court? Madam, may I just pause here for a moment? So my Yes. So, my lord, according to me, the question is 362 versus 482, and this has been answered. Paragraph 13, even otherwise, section 362 of the code places a bar on the court.
You become factus officio, therefore
No, I said that this is not altering, this is not modification. Recall is absolutely independent from either one of this. So therefore 362 does not apply in this case. Please read that, my lord, with paragraph 13 with me. Even otherwise, section 362 of the code places a bar on the court to alter or review its order or judgment. Once the judgment is pronounced and signed, the court becomes functus officio, and therefore no further alteration or review of the same is permissible, save and except to correct clerical or arithmetical errors. However, what is sought by the state in the incident IA is not an alteration or review, but recall of the entire order on grounds as have been noted herein above. In other words, if the IA were to be allowed, it would mean complete abrogation of the order and restoring the parties to a position they were prior to passing the order. There is thus an inherent distinction between alteration or review and recall of an order. In the case of Hon'Ble versus State of Rajasthan reported in this, a full bench of the Rajasthan High Court has held that the power to recall is different from the powers of altering or reviewing the judgment. In Pushpanga versus State of Kerala reported in this, the Kerala High Court held that 362 does not affect the powers of the High Court under 482 to recall or judgment or order if legal grounds are properly established by the party complaining. 16. The position that emerges from reference to the case laws noted above is that a bar under section 362 of the CRPC is not absolute and in any case does not apply in case of recall of an order. There is no dispute that the inherent powers of the High Court under section 482 of the CRPC can be exercised if any of the three conditions exist, namely to give effect to any order under the code, to prevent abuse of the process of the court, or to secure the ends of justice. In case any of the three conditions exist, the High Court would be justified in exercising the jurisdiction. Therefore, the objection raised by Mr. Panda with regards to maintainability of the IA is not tenable. However, whether such course of action is justified in the facts or circumstances of the instance case shall be discussed later. So, my lord, it has been categorically distinguished. So, 362 talks about review or modification.
But in that application, what was sought?
Which one?
In this CB.
Which may kindly see, my lord, what
was sought is there is a clerical error.
No, the proceedings were quashed.
Yes.
But if you kindly see, my lord, what is the facts of the case? Paragraph 7, my lord.
Come to page para 22.
Para 22, your lordship.
Yes.
Indeed, my lord.
Yes.
It is obvious that the aforesaid order was passed by this court on erroneous premises. That is miscalculation of relevant dates. My lord, why relevant dates here? Because on that date when this was...
Read further.
Learned additional counsel has submitted that the above fact came to his knowledge on being informed by the IO. Much later thereafter, the IA has been filed seeking recall of the order. Such being the factual scenario emerging from the above narration.
Yes.
My lord, so finally...
So in this fact scenario, the court dealt with everything and said that it's not an absolute bar under 362.
So, my lord,
Therefore, I'm exercising and correcting this.
my lord, I kindly appreciate.
But an a detailed order, a substantive order saying that a particular judgment is applicable in this case.
My lord, would
on the guise of modification.
No, this is not a modification.
Recall.
Yes,
Guide
sir,
of recall.
that is
Can it be answered? Then see what will the flip side would be. Suppose I pass an order which is not suitable to you. I demit the office. Next day you move an application.
Your lordship.
The same thing happens.
My lord, when your lordship has said,
It should have gone to the same honorable judge who has passed the order.
We have made various
Debited office today, and you move an application.
My lord, I'm
That
not
is
asked.
disastrous
My lord,
consequence.
yes, my lord, with the utmost of respect, I'm not casting aspersions on anybody.
See the consequence.
My lord, that might be a.
That's perhaps the reason 362 is designed.
My lord,
I can understand if I pass the order, tomorrow you come and say that, see, this is the circumstances, you have passed this order, this is missed or escape notice. So then I can recall it. I can understand that. See, the order passed by the former Chief Justice and he demitted the office. You move an application in the guise of recall.
My
and
lord,
a
is it in the guise
substantive
of
order.
recall?
How can I do that?
My lord, I asked myself this question, is it in the guise of recall? My lord, I have never been noticed. My lord, would kindly appreciate this fact once. My lord, why was I not made a party? I am the victim and the Honorable Apex Court says that the victim has to be heard in every instance.
Yes.
So why was I not made a party? Why was I not noticed? My lord, my first point is this, the violation of the principles of natural justice for the troubles that I have received, that should have been considered. Bare minimum. My lord, I am only on that. My lord, let me not go to Prem Kumar or other things. My lord, let me set aside the grounds of merits. I am saying that I may be heard. And then in case subsequently, in case they win, they win. But let me be heard in this matter. Let me be restored to a position before this order was passed. I argue on merits, I lose. That's my fate, your lordship.
How have you become a party now?
My lord, I came to know about the proceedings and then I instantly and immediately filed an application in August. There was a death in the family of my father and accordingly that is their cause of action and that is their grounds. But my grounds is that I was never noticed. Your lordship.
How did the court record that service?
Yes, may I submitted.
Yes, because notice was
the informant being the master and lost the affair, informant was a party. He was noticed twice. Your lordship, may kindly see the order. See, he was noticed twice. He received the notice from this honorable court.
Is your father?
My
Yes,
father. But I am the victim, my lord. My lord, my ground is this, that I must be noticed. You notice my father, he does not appear. Fair enough.
There is
Your father didn't appear.
My lord, there was death in the family. Your lordship,
no.
The second IA. My lord,
your lordship, there is two dates personal service was made to the informant.
See the IA, my lord, that is the death has also been reflected. The dates on which this has happened and why they couldn't appear.
And my lord, may I submit only one thing? Your lordship, kindly see the 353 of the CRPC.
My lord, what will happen? My lord, what will happen today?
No judgment.
My lord, they will happen again.
Why can't the petition be heard?
Yes, my lord, the fact remains, if a settled principle of law by the Honorable Supreme Court will be divested. And 2014 Honorable Supreme Court has categorical stated.
You want me to write a full judgment on this, or let us?
No, because my lord, I will why
let us give an opportunity to him and
yes, my lord, why I shall be once a judgment has been passed by this honorable court, and by act of the judgment the case has already been closed. 2 divorce case proceeding is there. One is closed, and then he has at his instance. I mean, the father's instance, the daughter has filed the divorce case, and I will not be prejudiced, my lord, when this judgment of the Honorable Supreme Court is clear in relation to 353 read with 362, 482 read with 362.
My lord, what is the harm? I ask myself, if he wins, if he has got a very good case, he will win on merits. He won it the first time, he will win.
When have you see this order was passed on 8/5/2023? When you the application?
My lord, I moved it in August 2023, your lordship. I moved it in August.
Your lordship, may kindly see.
When I was not even a party and I was not noticed, your lordship. Your lordship, may kindly see my application. 18th August 2023.
Show me the rule that you are necessary party.
My lord, the first judgment that I gave your lordship, my lord. The first judgment that I gave your lordship, I kindly have that. Paragraph 10 of the Honorable Apex Court.
Yes.
New India Insurance Company Limited.
Yes.
Paragraph 10, your lordship has at page 4, the last paragraph, and then the quotation of Davinder Pal Singh's judgment, paragraph 46, my lord. the test as to where it can be done, if a judgment has been pronounced without jurisdiction or in the violation of the principles of natural justice. I stop there, my lord.
No. You say, tell me, show me the rule. Show me the High Court rule where you are a necessary party.
Yes. High Court rules. My lord, may I take Monday's leave and argue tomorrow, my lord?
Yes. Because the informant who is your father was well represented. He didn't appear. Thereafter, an order was passed. At the beginning of the judgment, it is written that despite notice, he didn't appear.
I bow down, your lordship. Your lordship is
He
asking.
could have engaged a lawyer. There could have been a request on his behalf. Nothing was done.
My lord, if I may argue also for my father.
And the principle of natural justice impliedly complied because your father was represented.
Yes. My lord,
At the instance of your father, the FIR has come. And show me the rule that you are a necessary party. If you are a necessary party and thereafter you are not being heard, perhaps this New India may help you.
Yes.
Otherwise, no principle of
my lord,
nature.
let us see the application of my father, my lord. Please, your lordship.
No. That the father can't call for recall.
The father is also
For the father, he has a remedy somewhere else.
Right, your lordship. I understand.
I am examining you, not the father.
I appreciate.
Once the father calls you, then the father has a different remedy.
I bow down, your lordship. I bow down. I will answer this, your lordship.
Father has a different remedy.
No, my lord.
And I think you, instead of wasting time, you should resort to the other remedy.
My lord, financially very weak, your lordship. Extremely weak, my lord. Your lordship will also appreciate.
Chief Conservator of Forest, not financially weak.
There I will not venture.
My lord, if I have my legal remedy, if it.
My lord, may my lord, not tomorrow, my lord.
Not tomorrow. We'll give it.
Any date as your lordship.
I have to raise because
Yes, my lord. One request, the last item of the list, this is with regard to the interim bail the man has got operated. Some or other, it could not be listed yesterday. But today it is the last item of
Yes,
Yes.
my lordship, I have received right now.
positive or negative, you tell me.
My lordship, he was discharged from the hospital and
He is cancer patient. Why are you asking?
lordship kindly glance to the
16
last
तारिख रे हार्ट ऑपरेशन ता हेची ना नाही
he सारी ना से 22/1/2025 रे already discharge ହେଇକି ନା କିନ୍ତୁ absconded
नहीं तारो जो
ना they totally ना
I strongly believe you.
From the hospital on 22/1/2025.
and the petitioner Pradeep Das and his son Praveer Das were locally not available. Their respective house and the family members are also invited to
Exactly. ମୁଁ
discuss present whereabouts.
तारो ଚାଲିଛି kidney dialysis ମୁଁ ଆଉ ଗୋଟେ ବି document ଦେଇଛି probably
No, after discharge he evaporated.
And
No.
Today I received, my lordship. Kindly have a glance to the date also.
Where is he?
He's at Raipur, my lord.
And
But his
their family members are searching, police, everybody searching.
The only one member is at Koraput. Others are at that hospital.
This is the report. What to do?
Can it be taken tomorrow? Because I have got my friend is.
Are you sure that he is there?
Yes, my lord. Otherwise, I would not have, my lord.
But this report says that the family members are also searching.
The family member means consists father and son, and another person committed suicide, and only sister is staying at Koraput. One has left.
Yes, madam.
My lordship. I have received.
Let's give for one. See, the fact remains. Leave everything apart. Fact remains. He was hospitalized. He was operated, and he was discharged on 22/1/2025. Post-operational care is also required, and now kidney dialysis and all.
Yes.
Let us give another. As it is, you are supposed to surrender when? Supposed to surrender?
No, the warrant has been issued in October. I was supposed to surrender in August. When I was brought in ambulance, the court was extended. But in October, I could not surrender.
In bit of law.
Because there was multiple treatment.
You show me something that he is in dialysis, then I'll extend.
Yes, my lord. Some sorts of document is there on record.
Tuesday witness. Tuesday witness. Whatever there is extreme emergency, you will give a date. Because I have to go somewhere.
I mean, 37. Yes, sir, 61. I am there, the petitioner. I am also reading that case. Any date, item 37.
We will adjust the date.
Item,
item 6, my lords, interim order to continue.
Item 37, my lords, is passed over. But we will try to adjust all. This is a covered case. I was held up in another court and did not come. There is an order. My lord, Justice Saberi has dismissed as many as 340
I'll
cases.
take it up Tuesday. You are matter.
And Mike to that 37.
6 interim order to continue.